take my lord, the sketch, my lord, prepared by the petitioners, my lord, a hand sketch, my lord. My lords will find it being page 51.
Pass the tender notification dated
Yes.
bearing so and so.
Yes.
Is it the case that now the entire
Now, my
tender
lord,
is
insofar as
completed?
first prayer is concerned, my lord, I will not press because the work already the respondent number 4, my lord, has constructed the work, my lord.
And he has completed the
Yes,
work.
it is completed.
Then what is this representation?
Insofar as second prayer is concerned, my lord, may I request, my lord, in page 51, may
No,
kindly-
what is the representation?
Now, this representation is given, my lord, since, my lord, in view of construction of a bridge cum barrage, my lord, which is 15 feet height, my lord, and 45 feet length, my lord, width. So, my lord, once the bridge is constructed, my lord, during the entire period, my lord, the water will be logged in the said area, my lord. Because of which, my lord, the adjacent land, my lord, it will lose its fertility, and the area, my lord, will be in a meshy condition, my lord. Therefore, my lord, in fact, my lord, section 7 and 8 of the Land Acquisition Act, my lord, there is a specific requirement that, my lord, the scientific report has to be taken, my lord, before constructing of a bridge and other things, my lord.
No, it is already done.
Yes, my lord. My only request is, my lord, since, my lord, there is a water stagnation in the adjacent land, my lord, the entire property, my lord, of the petitioners, my lord, may I request, my lord, in page 51, may kindly.
Oh, what you want them to do now?
My lord, let them, my lord, acquire the property to the extent, my lord, the stagnation of water, and pay the compensation. Otherwise, my lord, the edge of the line, my lord, water stream, my lord, the property will not be in a position to cultivate.
Let them consider whatever they want
Yes,
to
that precisely my.
Whatever you want to do, you do.
That only my
Present
submission.
petition is seeking the following prayer. As far as the first prayer with regard to quashing of the tender notification is concerned, the land council appearing for the
Respond number 4, my lord.
respondent number 4 submits that pursuant to the tender notification, work is allotted to him and he has completed the work. He has completed the work. Hence, and the amount was not released to the petitioner, to the respondent in view of the pending writ petition. Considering the fact that already the work is executed pursuant to the tender notification dated 19/1/2025, nothing survives consideration in this writ petition as far as prayer number A is concerned. Coming to prayer number B, it is a case of the petitioner that. So for this purpose, you want the tender notification to be quashed?
No. Before issuing of the
How can such a prayer be maintained?
no. Before issuing the tender notification, my lord, the representation was given.
No. How can a tender notification be quashed? Because pursuant to the tender notification, if construction has come.
That precisely, my lord, section 7 and 8, my lord, requires that, my lord, a scientific report has to be obtained.
At that time
we were not
also-
heard in the matter, my lord.
At that time also, your prayer is only B. At any, because you have
No,
nothing to do with the
submit,
tender.
my lord, with great respect, my lord, we submitted a representation to the authorities.
You should pursue on that, but you can't
They
see
did
the
not
tender
consider.
file.
They did not consider
You have
the.
nothing, you have no business to ask
They
this.
did not consider the representation.
The second relief is to consider the representation dated 25/2/2025. It is the case of the petitioner because of the bridge or the flyover,
Barrage, my lord.
the barrage that is constructed. Now, the land which is adjacent to the, which is near to the said barrage, it will be always flooded with water and would be of no use for the petitioner. Hence, he has requested the respondents to acquire the land and pay the compensation. The said representation is, though he has given it on 25/2/2025, the respondents have not considered the same. Land council, land HEA submits that the petitioner, he'll get instructions in this regard. Next part, having heard the councils on either side, as a material non-record. When the petitioner has given a representation dated 25/2/2025, the respondents ought to have considered the same in accordance with law and ought to have informed the petitioner whether such a request of the petitioner can be considered or not. If not, the petitioner will avail the remedies available to him under law. In that view of the matter, this court is passing the following order. The writ petition, as far as prayer number A, that is quashing the tender notification, is concerned, the writ petition is dismissed. As far as prayer number B is concerned, there shall be a direction to the respondents to consider the representation dated 25 to 2025 in accordance with law within a period of 6 weeks from the date of receipt of the copy of the order. Yes.
Respondent number 1 and 2, madam. Respondent number 1 and 2 I have to consider. His
Respondent
representation.
1 and 2.
Good.
Yes.
Preliminary hearing matter, serial number 2. Girish Dharwad. Please. Nande Pachapur.
Day before yesterday's matter, my lord, petitioner before my lords is the defendant. My lord, respondents 1 and 2 instituted a suit seeking declaration, my lord, of a right of way. My lord, the primary contention of the plaintiffs is that there was a partition in the year 1972. All the parties, that is, my lord, both the plaintiffs and defendant, they are related, as in they are cousins. My father and his father, they are, my lord, brothers. Entire lands were belonging to one family. RS number 14 and 15, adjacent land, they were belonging to one family. They were partitioned in the year 1972. And in the said partition, there was a arrangement that this road should be left. This is the premise of the suit. That is, my lord, certified in terms of MA number 1956 in the year 1972 or 73 thereafter. On this basis, he claims that there was a right of way and, my lord, sought for injunction. He filed an application for temporary injunction. The trial court, upon meticulously considering this fact, that, my lord, he did not produce that partition deed wherein he says that there is a road left 12 feet into, my lord, some hundreds of feet, totally measuring 1600 feet, my lord, 12 feet into 1600 feet, almost about, my lord, 20 guntas of my land. Trial court, upon seeing that he did not produce that partition deed and that mutation entry which he produced did not show that, my lord, there is a road left, and the photograph which he produced, which I have produced before this honorable court along with a memo, did not show that there is a road or there is any mark of passing of a bullock cart or a tractor or whatever for, my lord, his agricultural operations, rejected his application. My contention before the trial court was that there is no road in my land as contended by him, first. And second, there was an alternative road in another uncle's land. Both of us had an uncle, my lord, whose land is further adjacent. There he had a land. It appears that there was some dispute between them. Now he is trying to, my lord, disturb my position. He preferred an appeal before the first appellate court. Now the first appellate court has reversed the finding of the trial court and has granted an order of injunction. That was stayed before this honorable court. That is in operation till today. As on today, my lord, I have standing crops of sugarcane. There is no road existing where he claims. And first appellate court, my lord, for the purpose of reversal, what it considers, my lord, on a mistaken notion.
Now, only the, now, during the pendency of the suit, now what will happen is, he will have the right of passage in your land, isn't it?
No, but there is no.
That is what is the, no, you are all admittedly, it's between the,
Yes, yes, my lord.
you're all the
No,
members of a family.
Yes, my lord. But my submission may kindly be
Where the
appreciated.
lands are adjacent to the other.
Yes, my lord.
What is that you will, what is the grave injustice that is going to cause?
Grave
you?
injustice that will be caused to me is, my lord, since there was no road, he will make a new road by destroying my crops. My lord, for granting justice to him,
Is he going to lay the road?
yes, my lord, he claims, my lord, 12 feet into 1600 feet road.
We are not laying
12
the
feet,
road.
my lord.
Lay the
No,
road?
no.
Yes, yes, my lord.
We are not going to lay the road.
No
madam.
issues. If he is going to lay the road, it's a different aspect.
Yes, yes.
If he is using the road, it is a different.
There is no road. If there is a road, my lord, he can use it. My lord, for the purpose of using any road,
That we will clarify.
it must be in existence.
We'll clarify. Like, he cannot lay the road, but whatever
No,
is
no.
existing.
As
he
on
can
today, my lord, there are crops. On the place where he claims the road to be in existence, there are my standing crops. My lord, at the instance of giving justice to him, my lord, my standing crops cannot be destroyed and, my lord, injustice cannot be caused to me. That is one submission. And further, my lord,
No, how can
the
he- how
most
can he-
important submission, my lord's second.
How can he use a road? How can he use it as a road when there is a standing crop?
Exactly, my lord. That's why the trial court declined to grant an injunction. Now, my lord, for the first appellate court exercising jurisdiction under order 43 rule 1, but what has to be done, my lord, I am relying on two judgments. Before that, I'll place one submission on record. How the first appellate court approached the matter. My lord, first appellate court mistook it that the trial court had rejected his application for injunction on the ground that there is an alternative road available. No, I'll take my lords through the order passed by the trial court. Absolutely, that is not the ground. My lords may kindly come to the order passed by the trial court. Page number 31, it starts, my lord, annexure D. I'll directly take my lords to the reasons portion. Page 37, my lords.
Yes.
I'll skip that first paragraph, my lords. On page 38, the learned counsel for plaintiffs vehemently argued that the father of plaintiffs, my lords are there, my lord?
Yes.
and defendant are brother and sister, and RS number 14 and 15 are the ancestral properties of Mother Khandi family. Further vehemently argued that in the year 1972, father of the plaintiffs and defendant and other family members have got partitioned their ancestral landed properties, and in the said partition, RS number 15/2A was allotted to the share of father of defendant, and subsequently, father of defendant released his rights in RS number 15/2A in favor of defendant, and accordingly, name of defendant entered in the revenue records of the said property. Further, in the said partition, RS number 14/2A measuring 1 acre 32 guntas and RS number 14/6 measuring 14 guntas, both situated at Mantur village, were allotted to the share of father of plaintiffs, and subsequently there was a partition took place between the plaintiffs and their family members in the year 2023, and RS number 14/2A and 14/6 were allotted to the share of plaintiff number 1, and 14/7 measuring 2 acre was allotted to the share of plaintiff number 2. This may be marked more next portion. Further, it is vehemently argued that at the time of partition in the year 1972, fathers of the plaintiff and defendant have left 12 feet width road towards southern side of the said lands between the boundaries, and accordingly all the hissedars of RS number 14 and 15 are using the said suit ABCD road for their ingress and egress to reach their properties, and they use to carry bullock cart tractors through the said road so and so. Therefore, plaintiffs have acquired right of way over the suit ABCD road by way of easementary necessity. Further, it is vehemently argued that on 26/2024, defendants suddenly started to disturb the peaceful use and enjoyment of the suit ABCD road by the plaintiffs for their ingress and egress to reach their land. Therefore, plaintiffs personally as well as through elders of the village have requested defendant not to obstruct the use and enjoyment of the suit ABCD road by the plaintiffs and defendant, not heeded to the request. Further, vehemently argued that the suit ABCD road is only road for the plaintiffs to reach their lands, and except suit road, there is no other alternative road for plaintiffs to reach their lands. Therefore, pray to allow the present.
Now please come to paragraph, page number 12,
Yes, ma'am.
middle of the paragraph, on perusal of the photograph,
Yes, madam. Page number 12, madam.
middle of the paragraph.
Yes, madam. That is the portion I wanted my lords to mark, madam. On perusal of the said photographs, it prima facie appears that there is no, before this, madam, the trial court considered that he has not produced the partition deed. There is no suit ABCD road measuring 12 feet in width is appearing, but a pathway can be seen in the said photographs, and there is no marks of passing of bullock carts and tractors can be seen.
What is that finding?
I have produced, madam, that is,
No, no,
it says there is a pathway. He claims 12 feet road. I have produced that photograph also, that for perusal of this honorable court.
this observation of the court,
Yes,
a pathway can be seen in the set photograph.
yes, yes, ma'am.
There is no mark of passing of bullock cart and
Yes,
tractor can be
because
seen.
he claims, his claim is that Murad, 12 feet road is there and he is using for it for agricultural cultivation by using bullock carts and tractors. That's why Murad trial court said
That pathway, bullock carts and tractors can't flow.
the photograph may kindly be seen for a moment. If Murad, it can allow tractors or this can be passed. It is his photograph, not mine. Along with the memo, Murad, I have produced. Whatever documents he had produced before the trial court, Murad, I
Now
have.
that observation, like as if it appears that the court should see that whether the bullock cart can go or not. That's the kind of.
No. What, that's why, Murad, for better clarity, my lords may kindly see the photograph. Page number 12 of my memo dated 27/6/2000.
The pathway,
But it is, yes,
it is a pathway.
no, there is, Murad, gap between the crop. If the photograph is seen, Murad,
According to you, he can't use this.
Murad, he can't use this. There is no road as claimed by him. But now he wants to use it by using tractors and other material by destroying my crops. Murad, if a tractor passes through this, my lords are clearly aware, Murad, what will happen to my crops. If there was no crop, what had happened is, Murad, all the while,
In the, no,
what had happened is, Murad,
pathway, you start having the crops, what the other person will do?
no, but there is no road, Murad. That's why my primary submission was, plaint also, my lords may kindly see. Premises 1972 partition, there is a road left. But it is his duty to produce the partition deed and show that there was a road. That is the prima facie fact that he should prove. Trial court, upon seeing that he did not produce that deed which is relying upon, but rejected his application. What is the fact is, Murad, that Shivappa Madarkandi, who is our uncle.
Please come to what is IA he sought,
Yes, Murad.
prayer in the IA.
Please. Page number 21, Murad. For the reason stated in the accompanying affidavit of the applicant plaintiff, this honorable.
Say that he is going to lay the road. You are saying.
No,
that
ABCD road as shown in the hand sketch map. Previous page is the hand sketch map. He shows.
he said he wants to construct the road.
No, that is what, my lord, he claims to be there in existence, 12 feet road. But he has specifically mentioned the measurement.
Forget about his claim. No, he is not making any construction. Admittedly, there are two, both your land and his land are adjacent to the
No,
other.
that's why, my lord, the hand sketch may be seen, how the lands are situated. I am not disputing this existence of lands, but road is disputed. Page 19 is the hand sketch.
Yes.
Yes, ma'am. 14, the one on the below is his land. On top is my land. He claims that in my land there is a 12 feet road. And he uses it for my plaint. That's why, my lord, plaint may kindly be seen. What are his pleadings? Paragraph number 6, my lord, more particular.
Disputes go on between brothers. in the
Brother and
same-
sister.
No, my lord, I'll tell what has happened is, my lord, all the while, since that partition, my lord, he was using the road in the other uncle Shivappa Mother Khandi's land. No, but that's why he was using it. There was dispute between those two brothers. What has happened is, my husband has died. I'm a widow. Now they both brothers, my lord, they fought. And that road, my lord, that Shivappa Mother Kandi closed. Suddenly, my lord, he barged into my land. Now he wants to claim that there is a road. That's why, my lord, this matter was, as my lord said, the brothers and sisters, for the very reason it was referred to mediation. My client was ready for both. Either, my lord, he will accept money and give whatever that road portion is there, my lord, he is ready for that also. Or, my lord, let him give equal extent of land in his land and take road also. But, my lord, he came twice. But he made a, my lord, scene like he's agreeing. Then, my lord, went off without, my lord, even giving a counter proposal.
No, that is not the case.
This is what has happened in the, my lord, mediations.
Since they admit in their written statement that regarding partition, they admit, my lords. There is a partition, the upper portion, my lords, went to the,
Court gives a finding that in the partition deed, there is no mention about what you are saying.
yes, no, mutation entry, it's a oral partition. What court says is, my lords, at page 12, my lords, moreover on perusal of the mutation diary is produced. It's a oral partition. Undisputed, since from 72 they have not disputed, my lords. Now the valuation has increased. Because of that, now, my lord, the dispute has arisen. But he is a servient owner, my lords, who is, I am in the dominant position, my lords. Now, whenever, my lords, such is a position, but they can't tell you go and take away from uncle's property now, when both are sister and brother. Till 72, since from 72 there is no dispute. Now, my lords, because there is valuation of the property has been increased, it is to the road. Now this cause of action has been shown that she started disturbing. But I have not disturbed at the time when she wanted to send the sugarcane or her crops. Then when she has already sent it. Now my sugarcane crop, which I usually send it through that pathway, now she is disturbing. She's telling you get an order. We try to settle it. They are not ready to get settled the matter. My only concern is this, my lords. Now, easement right by necessity has to be established at the time of trial, my lords. Now, till then, there has to be a protection, my lords. Even section 27 of, my lords, the Easement Act, what it says is, my lords, if a servant owner, we are not disputing the ownership. We are not disputing that pathway is also belongs to the ownership of my sister. What I'm saying is, law says, if he is a servant owner, he has to allow the dominant owner to pass by. If there is any damage to the property, it is the dominant owner who has to compensate them. We are not damaging, we are not laying road. Just whenever the crop is ready, allow us to use the pathway. That is the only thing we are, and that law provides for it. This has to be established at the time of trial, whether it's a oral partition or it's a written in the WS, they admit partition. So since 72 till date, there was no any objection. Now the valuation of the property has been raised. Now this is there is some dispute between brother and sister which has risen, and therefore this, or else what was the need for the plaintiff to come to the court, file a suit, seek an easement? There was no necessity for me. Since if I was using the alternate land, there was no necessity for me to file this suit and seek a pathway to send my crops. It's almost 1.5 months, my lords, the sugarcane crop. Therefore, I made this application for that. At least allow me to take the sugarcane crop, which is getting dry. I don't get even not the amount for the sugarcane if it gets dry. I'm a servant, not section 27. I will not say, Lordship may kindly take easements export office. $24 million. right to do acts to secure enjoyment. The dominant owner is entitled, as against the servient owner, to do all acts necessary to secure the full enjoyment of the easement. But such act must be done at such time and in such manner as, without detriment to the dominant owner, to cause the servient owner as little inconvenience as possible, and the dominant owner must repair, as far as practicable, the damage, if any, caused by the acts to do servient heritage. Accessory rights. Right to do acts necessary to secure the full enjoyment of an easement are called accessory. What are accessory rights? Not an illustration is being given. Then 27 also, my lords. Servient owner not bound to do anything. Servient owner is not bound to do anything for the benefit of the dominant heritage, and is entitled, as against the dominant owner, to use the servient heritage in any way consistent with the enjoyment of the easement, but he must not do any act tending to restrict the easement or to tender it exercise less convenient. So I will not cause any inconvenience to them. I will not lay any road. If there is any damage, I am ready to compensate that. And they have already removed their, along with the vacating stay application, I have produced the photographs that your lordship may see. Not after they removed their crop, thereafter not I have to take my crop lots. These photographs shows, lords, there is a pathway or there is a cartway.
Where is it?
Along with vacating stay, lords, filed on 18/11/20. 18/11/25.
So what he is referring to?
I don't know. He said with memo.
Hmm.
Memo is not, I don't have that memo. Along with vacating stay, I have produced these photographs.
That's what he was referring to.
Adena, then.
ಇಲ್ಲಿ ನೀವು ಮಾಡಿದ್ದೀರಿ.
At page number 3.
Yes, lords. Along with vacating stay application, lords, I have produced it. So this was, my lords, this your lordship may see the tractor where, my lords, we have carried the last year, my lords, that is on 10/3/25. The sugarcane crop, my lords, has been taken through this. Hardly, my lords, 4 feet, my lords, way they have to leave. And after, it's only after their crop is removed. And purposefully, if they do, my lords, my crop is already there. It has come for harvesting, and now they want to cultivate and sow seeds, so that I should not go. That should not be the intention. If there is any damage, if already the crop has come, then, my lords, that, my lords, the law provides for compensation for.
I have two submissions to make in this regard. In regard to the section 24 and 27, Marad, for that to be considered, Marad, it is to be first established that there is a road. For a moment, Marad, my lords may kindly come to page number 12 of my writ petition.
What do you say about that photograph? You relied on his photograph.
That is, Marad, that is also his photograph only.
That's what you relied on that. Why?
No, not relying. I am relying on that to say that, Marad, there is no road. That's why for a moment, Marad, page 12, paragraph number 3.
What do you say about paragraph?
No, that's why, Marad, for that very reason, answer to my lord's question, page number 12, paragraph number 3. My lords, of the writ petition, page 12, para 3 of his plaint.
Yes.
It is submitted, my lords, got it? Page 12, para 3. My lords, got it, Marad?
Yes.
It is submitted that lands RS 14 and 15 are situated adjacent. RS number 15 is situated towards eastern side of RS number 14, and the main village connect road is situated to eastern side RS number 15. It is further submit that at the time of partition in the year 1972, the fathers of plaintiffs and defendants are kept a common 12 feet width road in the southern portion of the said lands. Between the boundaries surlumbars of the said lands, there exists a 12 feet road since from 1972. But to claim all these rights, it is his duty to first establish, according to this, that there is a road. Even his own photographs do not show that there is a 12 feet road. That's why trial court said, you do not even produce that partition deed. You rely on a mutation entry that doesn't show.
At this time, let him take his crop only to.
No, but what will happen if that is allowed? That's what I am saying, Marad. There will be a new road created for the first time. But if it was there, I wouldn't have come this way. But he says that there is a road, doesn't establish it. That's why my submission, Marad. Now what the first appellate court does is, I am, Marad, making one legal contention before this honorable court. First appellate court, on a mistaken notion that the trial court rejected his application because there is an alternative road, that is wrong. But in fact, trial court does not reject his application on the ground that there is an alternative road. It rejects his application on the ground that, Marad, he has not established prima facie that there is a road as claimed by him. Now, if that were to be, Marad, let, Marad, a court commissioner be appointed by this honorable court. Let him take a sugar cane, but let him establish that there is a road. For that purpose, Marad, for the order. No, what happens is, Marad, now if he takes his sugar cane by passing bullock carts and tractors, Marad, a new road will be formed. But that he will use as evidence in the case at the time of trial. But that can't be done, my lord. That will cause total injustice. At that time, my lord, when if the later in the suit course, the court commissioner is established. Now today, what he will create, my lord, the court commissioner will say that there is a road.
No, every farm, every agricultural land to, for ingress and egress, there will be a path.
Yes, my lord. That's
There is a path.
no. He has to establish, my lord. It is his land. That's why I submitted, my lord. Earlier, he was sending a sugar cane through the Shivapa's land. Those two brothers, my lord, they fought in between, my lord. He
Will appoint an advocate commissioner to show.
certainly, my lord, I am ready. Let him show if there is a road as claimed by him, 12 feet road. If
As stated in this,
yes,
then if there is a pathway, what would be the,
plain paragraph number 3.
that's what I'm saying. If the advocate commissioner gives a report saying that there is a pathway, what would?
Then let him take a sugar cane through my land.
Then I will, we have to impose costs of.
Yes, yes, my lord.
The submission
My lord,
for the-
12 feet into 1600 feet as claimed by him. He has to establish that. Yes, my lord.
One is whether there is a pathway or not.
Yes, my lord.
Second question is whether there is a pathway as claimed by him of that dimension.
Yes,
So you make your submissions very clear. I'll record
yes,
it.
yes,
First submission, whether there is a pathway or not.
yes. Ma'am. No, there is no pathway.
So according to you, there is no pathway at all,
Yes, ma'am.
either of that dimension or there is no pathway. That I'll record.
Yes, ma'am.
Yes.
Now, the court commissioner may see whether there is a pathway or whether there is a rose claimed by him. Whatever it is, let it be placed before this honorable court. Now, he says, I have transported my sugar cane.
Let him do it in the weekend. I'll have it on Monday.
Now, now whether I will be allowed to take, because now,
Monday, if I don't hear the matter today, it will be pending till Monday, isn't it?
please, Mr. Mati,
I'll pass the order on Monday.
please.
The present writ petition is filed by the defendant, agreed with the order passed in. Where is that order?
My lord, annexure D, page 31. That is, I'm sorry, that is trial court, my lord. The first appellate court's order, page 45, annexure E, dated 22nd April 2025.
Translated copy of this?
I have filed yesterday, my lord, with a memo.
The order passed by the appellate court in MA number 7 of 2025 dated 22nd April 2025. Whereby the court had granted the injunction as prayed for, restraining the defendant from interfering with the passage of the from obstructing or putting obstruction for plaintiff's passage for their peaceful use and enjoyment of the suit ABCD road as shown in the plaint. Land counsel appearing for the defendant submits that there is no passage and the trial court had rightly held that he has failed to place before the court there is a ABCD road as shown in the plaint. Land counsel appearing for the respondent plaintiff submits that from the times immemorial that is used as a pathway. In fact, it is a joint family property, and after the partition, as for the oral part, it's an oral partition.
He doesn't say about either oral, but he says partition.
Oral partition through mutation entry, is there mutation entry has been produced.
Oral partition, and which reflects as per the mutation entry. There is an existing road, according to whom there is a standing sugarcane crop, and the way to take the produce is only through this passage. Now the petition defendant is obstructing. Considering the submission of both the counsel, this court deems it appropriate to appoint an advocate commissioner. The advocate commissioner shall visit where is the description? The suit scheduled property
Yes, ma'am.
by giving notice to both the parties and shall place before the court the report. One, whether there is any pathway, that is ABCD road as shown in the plate, number one. Number two, whether there is any pathway, whether of the same dimension or not, whether there is a pathway existing. Yes. The, they shall visit the Sue scheduled property on Saturday and shall place a report before this court on Monday by giving the copy of the, on Tuesday, Tuesday is better, on Tuesday, by giving the copy of the same, serving the copy of the same on both the both the parties. This matter on Tuesday. Who will be the advocate commissioner? Yes,
Jiraligan, MS Jiraligan.
so and so, what's his name? What is your name?
Santosh.
So and so is appointed as the advocate commissioner. What about his fees?
My lords may fix my lord his fees.
How much?
I'll leave it to because,
10,000,
please.
10,000.
Its lordship have said road, my lords. Lordship may say kacha road. Road means again.
As claimed by him,
Please.
Look at the plaint and
Please.
as claimed by him in the plaint.
so and so.
Please.
Advocate fee is fixed at rupees 10,000,
We,
which is payable by both the parties.
we'll share it, my lord.
Please.
Tomorrow we'll direct the parties at the spot to pay him, my lord, the,
Please.
Yes.
that should be. Please,
Yes, next.
Seal number 3,
that order copy, my lord, maybe,
agreement.
Today evening they'll get.
yes. Office may be directed to serve him that.
Huh?
Registry may be directed to serve copy of today's order to, my lord, the court
I
commissioner.
saw the copy on the council today, on the advocate commissioner.
Please.
Yes,
Seal
next.
number 3, CR agreement.
There is an interim order, my lord, until then, my lord, it may be.
Simple matters, the mandamus direction seeking. Very matters, my premises has been utilized by the state machineries for the purpose of matters the,
You have given representation to whom?
that's annexure A is the my representation.
To whom?
The two matters the district officer, respondent 1 and 2.
Please read it at annexure A.
A matters, Mr. So and so hereby requesting your authority to release the amount of so and so that as I have leased out my building newly constructed located in so and so area to bearing so and so number to your department under the rent agreement with effect from 1/1/2023 for a period of 3 years. The period of lease will come to expire on 31/12/2025 and building has been utilized by your department for the hostel purpose. There is no dispute with regards to the lease of premises for the hostel purpose. The Taluka officer again directed me to build another 6 rooms on the same premise. According, I have constructed by spending 35 lakh rupees. But unfortunately, without any intimation, you have decided to vacate the premises that too prior to expiry of the lease, and even you have vacated some of the students from the lease premises without intimation to me. On physical inspection, I came to know that out of 25 accords, so and so have been missing in the premises.
Unfortunate, the state is behaving like this.
And so kindly see, these are all the disputed facts.
Not
My lords,
disputed fact.
kindly, what is
If it is a
said,
disputed fact, tell them.
my lords, kindly see the my lords, what law, or the 2 lines in the first, my lords. I came to know that the 25 cot, 5 cot, 3 water purifiers have been missing in the premises and the door of the bathroom were also broken.
Apart from that,
Anyhow, my lord, we will reply to their, my lords.
that's what you do it. Why should people come to
Please.
court every day for this?
Please,
In fact, my lords, last week, they have released some amount, my lords, so 4 lakhs and 50,000 yesterday, my lords, intimate.
After the writ
That after the Miller's petition,
4 lakh?
remaining 4 lakhs 53,000 and odd.
Anyhow, I'll only record
Please.
that. Let whatever is the representation, let them
Within
consider
a
it
time
done.
period, Millers, because within a time bond period, because Millers,
Fine, we will
please.
say, but I will not direct them to.
No,
pay
no,
you
no,
the
I'm
amount.
not saying that also.
Yes, the present writ petition is filed, seeking the following prayer. It is a case of the petitioner that is the owner of the building constructed in survey number 224 plus 225, plot number 5, bearing PID number 17/2612, plot number 17, located at Ravindra Nagar, Dharwad. After completion of after constructing the building, he has leased out the building to the respondent authority for the period of 3 years, commencing from 1/1/2023 until 31/12/2025. The respondents in pursuance of the lease has occupied the premises and utilized the same for ladies hostel. It is a grievance of the petitioner that even before the expiry of the period, they have vacated the premises. The respondent authority, without even informing the petitioner, vacated the premises. Earlier, he has filed WP number 107089 of 2025, seeking a mandamus to consider the representation dated 24/10/2025. But the same was rejected on the ground that the writ petition was filed immediately after the representation submitted to the respondent, and no time has been granted to the authority. It is submitted that now, even after expiry of your representation is dated.
That's 24/10/2025.
How many writ petitions you will file?
Earlier, writ petition was filed in the immediately by giving the representation. That has been premature. That is been mentioned.
According to you, this is matured.
Please.
How?
That's 24/10/2025 a representation. The writ petition was filed on 15th December. 2 months waited. Because there is no dispute with regards to the leasing, but only regarding they are saying that finance have not been accorded by the
You
submit.
should at least advise the client after getting that writ petition dismissed. You should have waited. 2 months is not a big time that where issues of the government are concerned, that such an inordinate delay that you should rush to this court and seek a mandamus for this.
Please.
What did you write? Even after 2 months, 3 months, the respondent, this writ petition is filed on 15/12/2025. It is stated that they waited for 2 months as there is no response. They have come before this court. It is a contention of the land comes for the petition that during the pendency of this writ petition, an amount of ₹4,53,000 is paid by the respondent. Next, Land Council, AGA submits that the petition is representation has raised several disputed questions of fact, and the same cannot be decided by this court. Next, having the councils on either side, peruse the material on record. The petition has given a representation stating that the respondents have to, or there are certain outstanding amounts to be paid by the respondents. Whether the petitioner is entitled or he is not entitled, there is a responsibility, obligation cast upon the reserve. Which respondent you are? Yes?
1 and 2.
1 and 2.
1 and 2 to reply to the same. Unfortunately, there is no reply received by the petitioner. In that view of the matter, this court is passing the following order, saying so and so shall be considered for respondent 1 and 2 within a period of 6 weeks from the date of receipt of the copy of the order. In accordance with law, shall consider and pass appropriate orders.
Yes, I'll take notice.
So and
Take.
so.
Number 4, Sandeep Osman.
Yes.
My lord, appearing for petitioners, Lord, petitioners are seeking mandamus in the petition. Petitioner 1 and 2 are the petitioner 1 is
Mandamus to whom? Which respondent?
my lord to honorable court to adjudicate the pending OS to adjudicate the pending original suit filed by the petitioners in the case OS 490 of 16 in the file on the file
I asked you, you gave representation to whom?
petitioners 1 and 2
Petitioners?
1 and 2 representation.
Huh? What is the mandamus?
My lords, my lords, there is a suit pending in the
Which
honorable
year is the suit?
my lord,
Which year is the suit?
2016.
2016.
Suit has been filed by the petitioners for a declaration, permanent and mandatory injunction in respect of Schedule A and Schedule B properties against
The registrar judicial shall get information with regard to the pendency of this court, 3rd additional civil judge and JMFC Belgavi. This is matter on Tuesday. Tuesday it will come.
Seal number 5, Ode Nagaraj.
I am for the. Lord, this is seeking on compassionate ground, my lord. Transfer seeking on.
Of my lords, the fair price of license,
I see.
compassionate.
Okay, yesterday also, that's what
Yesterday
I
also
asked.
same, my lords.
It may kindly be adjourned by 2 weeks.
Yes, discussed for 2 weeks. At the request of counsel the petitioner. Have you seen this?
Yes.
When the Justice Arur was disposing of the writ petition,
Please.
you have not even brought to his notice that the judgment where in the other writ petition, what is considered is about 10th standard. The petitioner will say it is covered. It is a duty of the government to
My
tell.
lords, one judgment says that even for my lords, for one-time measurement, even the my lords, the age also to be my lords diluted.
Age,
Age
it
also.
only speaks about age of
Yes.
they were speaking about the age of the children, not age of the father.
No, it's age of the my lords, original licensee.
Then give that order. we will give it.
Yesterday's matter it was
No,
there.
that is not so. I've seen that. You should have read that order.
Please.
It was an order pertaining to the
Please.
10th. Sir. What has happened? One order of the Justice Dinesh Kumar, I think, it is about the 10th standard qualification was an order.
Please.
Then the matter that has come up before Justice Arur is pertaining to the age of the father. And in the light of the submission that it is covered by that judgment, he has disposed of the matter. How will that be covered? It is altogether a different issue.
So the-
No, generally what happens whenever the petitioner says it is covered.
Serial number
what we
9 matter.
consider?
Serial number 9 matter, the judgment is produced. Serial number 9.
Serial number?
9.
Huh?
Serial number 9 in the my lords list. Petition is in serial number 9.
Serial number 9?
9 in the petition, my lords, in the list.
In this also judgments are there.
No, it is a judgment of Justice, my lords, P.S. Dinesh Kumar.
That is there, I saw it yesterday.
Please, that.
That is with regard to the children. About the 10th class and all, it is discussed. Please come to that.
Lords, may I take to my lords, ink page number 46, operative portion.
40?
46 in that petition, my lords, 1000852, please. My lords, I will go to relevant, my lords, order, column B. Keeping in view of the peculiar circumstances of the case and,
With reference to the age of the children.
Yes.
The discussion you should see. You should see the discussion in the internal paragraph.
Please.
The condition of pass in 10th standard is a reasonable condition. That is with regard to the children.
my lords, restriction of age, my lords, kindly see, para 31,
Para,
31. 31 ink page number 46, my lords,
that's what
please.
10th standard is of the children.
That
Now,
is a
the
10th
issue, whether the first condition,
Please.
if the father is above 60, father is
65.
above 65,
Yes,
then they are not entitled.
they are not entitled.
Once the father is above 65, and
Yes.
then what are the conditions to be fulfilled by the children or the next ones? That
Yes.
is dealt in this judgment.
Yes,
Father's age was never dealt with in this judgment. When the matter comes up before Justice Arur, please look at that order.
Annexure P,
Father, the petitioner was able 67 years, which is considered to be overage. So that issue is no more res integra.
yes.
In WP number 106521 held that the would not go be a ground to reject the application. Where is this order? WP 106521. Where is that order? Get this order. No, in all these covered judgments, ultimately when you see, there is no covered judgment at all.
Yes, they are
It is
different.
only submission of the council, acceptance by
They
the
are
respondent.
based on different facts of the case, my lords, not on the my lords. No strict jacket can be, my lords.
Then-
Fast, yes.
But that's why you should oppose it.
Yes.
When they say it is covered by judgment, you should be able to tell the court,
Yes.
it is not covered.
Please, please.
Get this order. Then come to page 52
Put it
of
off.
the same judge, same writ petition. No, in this writ petition, what is this? It says, petition is the son of the original licensee after the death of so-and-so. Father of the petitioner is overaged,
Yes.
as per clause 13 of the control order. And counsel for the petitioner relies on batch. This is Justice Dinesh Kumar's order.
Yes,
In the light of the above, writ petition is allowed, which is never decided by Justice Dinesh Kumar in that order.
Yes. Some,
Please get the judgment
Please.
now itself. Take a printout, it must be there in the, it is WP 106521 of 2019. If it is just Dinesh Kumar's judgment itself, then don't take a printout. If it is not, then please take. Please wait.
Please.
Yes, next.
my lords, it is in serial number 9. Justice Dinesh Kumar judgment is there.
It is there here also.
Please, it is not in the first case. Second case they have produced. That is in page number 31 in the, my lords, the second case, that is serial number 9, my lords. 100852 petition.
Same judgment.
Same judgment.
That is the problem.
Yes,
See,
yes. Kindly see, in page number 31, judgment passed by the honorable.
page number 31, where do you get it? Writ petition number?
Writ petition number, my lords, 13559.
No. This number is what? Just now I said.
10651.
10.
65.
What is it? I'll take a printout of it. It is a different judgment.
Please. Kindly have to, next week once I will clarify everything.
No, let it be. When
Yes.
the judgment there, what has to be clarified?
Yes.
Take a printout of that. Call the next case. Yes, next.
Seal number 6. KL Patil.
Day before yesterday's matter, my lords, tender matter. Tenderer who was awarded the tender of repair of road, he has completed the entire tender work way back in 2022. Subsequently, a complaint is filed saying that the road is of substandard nature, etc. Then Lokayukta conducts a preliminary inquiry. In the preliminary inquiry, the expert committee says that one component is found to be of lesser quantity.
He has to get instructions.
I have to take.
I was told to file translated copy of the impugned order.
No, apart from that, I've asked
Yes,
you
I have
to
to,
get
yes,
instructions.
yes, my
Have
lords.
instructions.
No, no instructions. Sir.
My submission is this. In respect of a tender,
No, I understand that. We will pass orders, let him get instructions.
Yes.
And already I think you have taken notice on. the
Notice
council.
has
notice is not
ordered.
ordered.
The AG takes notice on behalf of the respondent and shall get specific instruction whether an opportunity is given to the petitioner before passing such an order.
Please.
one
listen.
submission. Respond number 3 is a private person. For
Notice
him,
to respond in number 3, 1 and 2, AGA takes
Please.
notice.
one submission. Till my lords, some interim protection is
I will take it
granted.
up on Tuesday.
May I request in preliminary hearing, my lords?
Yes, in the preliminary hearing.
Okay.
Yes, next.
My lordship, petitioner is the
At 1 minute.
5. Seal number 5 and 9. Good enough.
What is this WP 10350? Take out that. It is like a chain reaction. 103504. 04. 2019. Look at it.
Please.
103504 of 19. PDS. GM PDS.
It is by whom?
Yes. Yes. G. Narendra. This is Narendra.
When was the amendment?
Amendment in the, my lords, 2020.
20?
20.
So this order is on 15th February 2019. That is much prior to the amendment.
Sir, I'll,
Look at the amendment. When
yes,
is-
please. Amendment was, my lords,
Huh?
amendment was, just a minute. amendment was, my lords, on 2020, sorry, my lords, 2021, 16/1/2021. And my lords, the judgment passed by the Justice Dinesh Kumar even after the amendment also. That is the whole difficulty.
His judgment is after the amendment.
Yes,
No,
this is before it appears, before the amendment. 2019 judgment, my
both
lords.
Justice Sunil Dutt Yadav's judgment and Justice Narendra's judgment
Yes.
are before amendment.
Yes, my lords. The, my lords, Justice Dinesh Kumar's judgment is after amendment,
See, what is the date? After amendment.
after amendment.
After amendment, not connected with the age of the father.
Yes, age and also the,
At least you remember from now on.
yes.
Yes. Please do make your, file your objections in that.
Please, I will.
Yes, next.
Seal number 7.
My lordship, petitioner is the defendant in the trial court, my lord. Plenty filed the suit for declaration and injunction, my lord. After issuing of the summons, petitioner not filed the written statement within a time, my lord, for due to ill health and
Which time?
only 29 days, my lordship.
Delay. After 120 days.
After 120 days, she, due to ill health and non-availability.
True. But where is the power to condone the delay? Or where is the discretion vested with the court?
My lordship, earlier that he filed the suit and all the documents are with the another advocate, my lord. Due to that, he can.
Understand, in view of the amendment, there is no power to the court to condone it. You shall.
In so many
File
instances,
it within.
my
so-
lord.
so.
In so many instances, there is a condemnation of delay, my
No
lordship.
instances. Show me one incident.
One-
Show me one incident. No incidents after amendment.
Kindly, my lordship. Due to ill health, my lordship.
Yes.
There is no inordinate delay, there is no inordinate
No, no,
delay.
it's not about
First,
inordinate
there is a
delay.
delay of 29 days.
After the amendment, after 120 days, there is no, the court, there is no may. It is shall.
Normally.
Shall not, the court shall not.
True,
So,
Mullah, I
when
agree.
once the provision says, court cannot interpret it in a different way. That's what is the position as of now.
What I request.
I don't know how
Mullah,
when if the Supreme Court interprets one day, then we will follow it. But right now, we cannot.
There is no inordinate delay. There is no
Not,
inordinate.
it doesn't speak about inordinate delay. It gives a timeline. Within 120 days, you shall file the written statement. After that, there is no discretion to, where is that amendment? Amendment is very clear. The court must have extracted that amendment also. Already, amendment is there in this. Where is it? Open it.
At least by Millards, by imposing a fine, Millards, that application. By imposing a fine, that may be allowed. It is informed that, by challenging the validity of that amendment, some petitions are filed. Yes,
That's what, till it is decided, we have to follow this, but because nothing could be in vacuum.
At least, Millards, by imposing a fine, Millards.
That's what you are not, what you have to understand is if the discretion is vested with the court, there are instances where they are filed after 2 years, 3 years also. But that's an amendment. We have to adhere to that. The present writ petition is filed. Agreed with the order passed in OS number 306 of 2025, dated 8/1/2026, whereby the court has passed an order observing that the right of the defendant to file the written statement is forfeited. The court observed that the suit summons were served on 22/8/2025. The period of 120 days is already completed and the right to file the written statement is already forfeited. Hence, there are no grounds to allow the application. Land counsel appearing for the petitioner, the defendant submits that because of the ill health, he could not file the application, he could not file the written statement, and the delay is only 29 days. Court can take a lenient view and court can condone the said delay, and court ought to have permitted the petitioner to file the written statement. Next para. earlier, before amendment, there was a discretion vested with the court. By seeking the leave of the court, the party is permitted to file the written statement. Now, after the amendment, amendment reads thus, that in the other case we have extracted. Amendment reads thus, as per the same, after the word shall denotes that there is no discretion vested with the court. In that we have
The Lordship's permission. One judgment, not so that is with respect to commercial suits, wherein the Supreme Court, my lords, has permitted to file written statement even after the cross.
that you have to take it to the Supreme Court, so and so. Accordingly discussed. That is the entire discussion is in that, basing on, you ask whether you have taken or they have taken. Yesterday I have discussed. Yes, please, sir.
Seal number 8,
Serial number?
seal number 8.
For petitioner minutes. May I take minutes for a moment? I am challenging the compromise petition. Minutes annexure B minutes, page number 10.
No, what is the suit for?
Minutes suit was for partition.
Who are you?
Minutes I am minutes if a family tree is looked into minutes I can point out minutes.
Yes.
Minutes annexure B page 10 minutes. May I produce the translated copy that is in Kannada?
Take that. Take.
Minutes admittedly minutes. This minutes Mullah Abdul Karim minutes is the propositus. Minutes he had three sons minutes. One is Murtuja Saab, Imam Saab and Nane Saab minutes. I am minutes representing minutes the branch of Nane Saab. This being so minutes, the branch of Imam Saab minutes, that is minutes, minutes may kindly from the bottom minutes third line, Imam Saab and Ajmer Saab, who are minutes grandchildren of this Imam Saab. They get a suit filed minutes. This Imam Saab files a suit as against Ajmer Saab without arranging minutes, no one minutes in of the family member as a party. They get a suit filed and minutes they get it compromised. Minutes may can
Compromise.
please. Minutes annexure C is the suit filed minutes between Imam Saab and Ajmer Saab. Wherein minutes, so far as family tree is concerned, which is at page number 12, minutes they are not even shown what the other branches. Page 12 minutes. What they do is minutes, they show minutes this Mullah Abdul Karim minutes as a propositus, who had minutes only son minutes by name minutes Mahbub Saab.
Imam Saab and
Ajmer Saab.
Ajmer Saab. Ajmer Saab is where in your
Minutes from the bottom minutes. I have not shown it as minutes respondent number 1. This Imam Saab files a suit against Ajmer Saab.
no, that this Imam Saab is the grandson of Ajmer Saab is the grandson of Imam Saab.
Imam Saab. Again, grandson is named as Imam Saab. So minutes
The suit is
for partition between these two persons, Imam Saab and
Ajmer Saab are only shown.
only. None of the family members, none of the branches are also
Please
represented.
come. Agreed with the judgment and a compromise decree. Where is the compromise decree?
Note page number 14, annexure D. This is the compromise
Agreed with
petition.
the compromise decree.
Decrease minutes at page number 19, annexure F. Sorry.
Dated 12/7/2025. The petitioner, who is a member of the joint family, who has not
Correct,
made a
please.
party to the compromise petition, has come up before this court. It is submitted that the family tree is placed before the court, stating that Mullah Abdul Karim has two sons.
Three
Murtuza-
sons, please.
Huh?
Three
Three
sons.
sons, Murtuza Sahib, Imam Sahib and Nane Sahib. And the petitioner belongs to the family of Nane Sahib. Now, the present suit for partition has been filed by the grandson of one of the brother of Nana Sahib, that is Imam Sahib, and the grandson of Imam Sahib, that is Ajmer Sahib, are shown as the parties and the suit is filed, and they have obtained a decree where all the family properties or joint family properties are part of the said decree, it is submitted that this is a collusive decree obtained by the. No, this is not an award.
Please note,
This is not an award.
please note,
It is a compromise decree
please.
passed by the court.
Notes here, what happens, notes, so far as, notes, it is passed by Lok Adalat. Notes.
Where do you get that?
Please, notes, page number 18,
Page number?
18, notes. 12/7/2025, the case is taken up before National Lok Adalat.
What did you write? Obtained by fraud, and the same is liable to be set aside. Considering the submission of the council, they shall be stay of execution of the compromise decree dated 12/7/2025 till the next date of hearing. Petition is permitted to take out, no, nothing is pending, emergent notice.
Great.
Yes, next.
Seal number 9, urgent. Seal number 10. PS Sankti.
My lords, this writ is on the issue of a court fee, and the plaintiff have filed a suit for a declaration and the cancellation of a sale deed. The plaintiff itself, they already agreed that in plain market value is 4.5 crore rupees, and the guidance value is 3.46 crore rupees. But they have already paid 49 lakh rupees, my lord. So we sought for a stay here. We sought for a stay here.
What are you questioning? Quashing the impugned order passed on
Annexure D,
additional
ma'am.
issue number 2. So what is this petition? WP? Why there, this is, why it is RES? But they are missing on that also. It is a CPC matter. Tell them yesterday also. Even they are not able to number the cases properly. Where is the impugned order?
My lord, Annexure D,
Page
issue number 2, my lord.
Page number 2. Which page number?
32 to 109. 38.
Order, where is the order?
Sorry, my lord, this pagination is not correct actually.
Well, come prepared. Tuesday. Yes, 11.
Seal number 11. Seal number 11.
Before the
Shraddha
petition,
Skardev.
Yes.
for petitioner lordship. Lord, the petitioner is the judgment debtor. Respondents are the judgment lord holders. In an MSC case, lords, certain amount has been awarded. Lord, that has been challenged before this honorable court, lord, that has been stayed, lordship. This being the fact, lord, in an execution petition, lords, the order, lord, came to be passed, lord, attaching the salary of, lord, to the extent of 1/3. Lord,
No, when the stay is granted, why would there be execution?
in an, that is the, lord, my submission,
You
lord.
should have gone to the MFA court. Questioning. When
No,
there is
now, my lord, order came to be passed, lordship.
When there is a stay, why will the court execute the order? If it is doing it in spite of the stay, you should have brought to the notice of the court in the appeal.
No, this is an independent order, my lord. I have to, my lord, challenge this order. Unless and until,
When the execution is stayed, why will an order be passed in the execution?
Lord, kindly see, my lords, page number 27, my lord, order on I number 2. They said, my lords, before the trial court, my lord,
On facts, is it clear that
please.
execution is stayed by the High Court or not?
It is stayed subject to deposit of 10 lakh rupees.
Including deposit.
It is not done.
Then there is no stay.
It is
There
not
is no
done.
impediment for the court to execute the order.
That is what, my lord, they filed, my lord, memo stating that.
So now, when you don't obtain a stay of execution and the court passes an order in the execution, why should this court interfere?
Lord, my only, my lord, submission is this, lordship. If it is attached, my lord, 1/3 of the salary, my lord, the take-home salary, my lord, to the only, my lord, he will get up to 5,000 rupees, lordship, out of 60,000 rupees salary. Lord, he cannot run, my lord, his life. My humble submission, my lords. It may be fixed, my lord, 10,000 rupees per month. My lord, I will pursue that MFA, lordship. It is filed, my lord, on the, my lord,
If it was filed when?
please, immediately after passing the judgment, lordship.
Which year?
Please, I have also produced, my lords, daily order sheet, my lords, Annexure C.
So you can give the date that is
Please,
sufficient.
please. Page number 17, Annexure C, my lords, it is filed on 29/9/2020.
No,
Execution is filed 2025.
2000, from 2020 successfully till 2026, you could stall the execution without even paying a single fine.
Lord, we are also trying for settlement, lordship.
Forget about all that. A person who is having a decree in his favor in the year 2020 is not able to realize the fruits of it.
No, we
till
are not.
2026.
My lord, it is our obligation, my lord, we have to pay. But, my lord, to some extent,
Decretal amount.
my lords,
What is the amount?
please, decretal amount, my lords, is 25 lakh rupees, award amount.
So with this 10,000, how many days you will pay 25 lakhs?
Lord, initially, my lords, in the meanwhile, my lord, we are also, my lord, settling the matter.
You have already enough time to settle the matter of 6 years. Let others come, notice.
Lord, now, my lords,
Let them come, 1-2 months, it is not
Lord,
going to
instead
happen
of, my lord,
anything.
1/3, my lord, it may be fixed.
1 month, if they deduct, nothing is going to happen. Take out notice, petition is permitted, take out hand summons on the counsel of the respondent and file a memo. Once they come, we can ask them.
Please.
Yes,
Bill number 12. Ashok Gurji, would appear.
yes.
The petitioner lodged a complaint, my lord, with the respond number 4, my lord, alleging, my lord, certain mismanagement and misappropriation of funds of the 6th respondent, my lord. And the elections, my lord, as contemplated under section 11, 12, 13 was not conducted by the 6th respondent. And the books of accounts were also.
So cooperative is a societies are listed caption.
This is Societies Registration Act.
I understand. How, what is for CS or ES? Huh? Yes.
But the election to the 6th respondent society was not conducted, my lord, as provided under section.
Please come to the prayer.
Yes. My lord, before that.
Respondent number 1 to take action against respondent number 6 society.
Yes.
In pursuance of the letter dated 31/1/2025.
Yes.
Who is respondent number?
1. Respondent number 1, my lord, is the Register of Cooperative Societies.
Respondent number 1 is state of Karnataka.
1 is State of Karnataka, 2 is Register of Cooperative Societies.
But who has to take action?
1 and 2, my lord, both have to.
Why and 1 and 2 will take action?
Lord, it is the 2 is the competent authority, my lord.
Then why did you give representation?
No, since, my lord, the report was submitted to the respondent number 1 by the respondent number 3. Not Annexure C is report submit, not an inquiry was conducted under section 25 of the Act, my lord.
Yes, what do you say?
Yes, I'll take notice, my lords, for the respond number 1 to 5. And
AGA takes notice on behalf of 1, 2 also.
1 to
2,
5.
3, 4, 5.
1, 2, 3, 4, 5. Notice to the 6th respondent. Get instructions.
Yes.
The AGA shall get instructions. This is matter on 17.
Please.
Yes.
Lord. Lord, I represent the petitioner in this case, my lord.
Yes.
My lord, this matter is pertains to land acquisition, my lord. And it is connected with the review petition number 100146 of 25, my lord. It has to be made over to the roster, my lord. Court roll number 7, my lord.
Submitted that this matter is connected with, tell the number to the court officer. So and so.
Please, 100146.
Before the matter pertains to land acquisition. Then why is it numbered as GMRES?
Lord,
Tell the registrar what is happening. The
Please.
submitted that roster is the other court and this is connected with the review petition number so and so. Just along with that before the bench having roster.
Number ready, sir. Abhilash.
100146 of 25.
Last thing.
Yes,
Please.
next.
Seal number 14.
Please.
Santosh Kumar.
Lord, impugned communication is page 26. This is a case where, my lord, petitioner is a company, my lord, engaged in the business of as an intermediary, just like Google Pay and Paytm. Now, there appears that what fraudulent transaction has taken place by some person, my lord.
Say the order.
Well, page 26.
Order dated bearing number. BNS issued by respondent number 1.
Yes, this respond number 1 is the cyber cell, my lord, without reporting the incident to the magistrate, without registering the FIR. They have simply issued a communication to my banker saying that defreeze all 4 accounts of my company. I'm not the beneficiary. I'm not initiated transactions. I'm just like Google Pay and Paytm. I'm providing intermediate services.
I take instructions, I take notice for R1, my lords. Take instructions.
The AGA takes notice on behalf of the first respondent, and the AGA shall get specific instructions whether any crime is registered against the petitioner. Whether the same is brought to the notice of the magistrate. If it is brought to the notice, which court the matter is pending,
Please.
so that the petitioner would be in a position to file an appropriate application before the concern seeking defreezing of the account.
Respond number 2, my lord, is the
You get notice to the second respondent. When
Yes.
will you get instructed?
Please, by next week.
Yes, this is the matter on 12th.
Please, obliged.
Yes, next.
My lord, with kind permission, may I submit, my lord?
Hmm.
My lord,
Yes,
my lord, in previous matter, my lord, the connector matter is about to list on 9th or 10th, my lord. This may also,
list along with that.
please, my
Yes.
lord, please.
Yes, next 15.
Seal number 15. Santosh Kumar.
Please, my lord, amendment to the written statement is rejected.
Hmm.
Page 3, page, my lord, last.
What is the suit for?
Suit for partition and separate possession.
You are the,
Yes, my lord, I am the one of the sharer. Lord,
you are the plaintiff or the
I'm
defendant?
the defendant, my lord. I have defend number 2.
When is the suit, which year is the
Suit is of the year, my lord, 2019.
And what is the amendment now?
Amendment, my lord, seeking the pleadings with respect to partition that has taken place in the year 1958, 2018 and 2019. These are all registered partition between the parties. Now, lordship may kindly see the genealogy. Now, this is the genealogy, 4 generations, my lord, suit has been filed up to 4 generations. There are about 4 generations, my lord, the partition has taken place.
Why all these are not in your notice all these years?
No, my father had filed a written statement. He expired, my lord. Thereafter, I entered as a legal heir, different number 2A.
When did you enter?
My lord, in the year, amendment is there. My lord. Recently, I have entered into the,
Let's see the order. Come to the order.
yes. Paragraph number 8, 9, my lord, last 4 lines. Annexure E, my lord. Annexure E. Paragraph number 9, that page, my lord, last, internal page number 3, my lord, last 4 lines. May I read? It starts from, by way of amendment, the defendant number 2A seeks to include pleadings about partition in the year 1958, in the year 1995, and in the year 2019, and another registered partition. The said alleged partition taken place much prior to the in time of the year of filing suit in the year 2019.
Doesn't state.
Already, plaintiff's evidence. Plaintiff's evidence is recording.
Then counsel appearing for the petition submits that there are registered partition deeds of the partition deed dated 7/11/2014, 1995. And the same were not, under 1958, all these things were not brought to the notice of the court and the earlier written statement. And as such, the petitioner wants to file an application under order 6 rule 17. And the same came to be dismissed, as these earlier partitions were very much necessary for adjudicating the dispute between the parties. The court ought to have allowed the same, considering the same, they shall be stay of all for the proceedings.
Please.
So the petition is permitted to take out hand summons and file a memo to that effect by 25th February, or else the stay granted by the court stands vacated. In this notice to respondent, in addition. Yes, next.
Seal
Please.
number 16.
Obliged.
Yes,
16.
For the petitioner, my lord.
yes.
Petitioner being the natural guardian filed a petition under section 7 of the Guidance and Wards Act, my lord. During pendency of the said proceedings and also sought, my lord, to sue permission to sell the minus interest property, my lord. During pendency of the proceedings, my lord, the respondent filed an application under Order 1, Rule 10(2), my lord. As he is stating that he being the father-in-law, he has interest over the property, my lord. The court come to conclusion that the father-in-law is also a class.
No. Who is the guardian OP is filed by whom?
Mother, ma'am.
By the?
Mother, ma'am.
By the mother.
Please.
Father-in-law is, that is the grandfather of the child, paternal grandfather of the child.
Please.
Has filed an application under Order 1, Rule 10.
Please.
The properties belong to the grandfather.
No, ma'am. The property belong to the husband of the petitioner, my lord. The property has been part.
See what it is.
If your lordship see, my lord.
Who are the respondents in the?
Please.
Let's see the guardian OP that's filed. That petition GNWC.
At page number 10, my lord.
The respondent, you want you to be. Let's see the release. The petitioner be appointed as guardian to the property of the minor, Kumari Komal. Grant permission to the petitioner to sell the interests of the minor in respect to the property, undivided share and interest in the co-parcenary property.
Mother and daughter having one share, ma'am.
Correct. So the co-parcenary property, why not the father-in-law is a necessary party?
Father, it's a special enactment, my lord. The suit has been partitioned along with the.
Now, how can there be such a relief? How can you sell? You say that undivided co-parcenary property, unless and until it is.
It's not a co-personal property, my
I am
lord.
looking from your pleadings. Come to page 13.
Why it?
Read 13B.
Please, I read, my lord. This honorable court be pleased to grant permission to petitioner to sell interest of minor so and so, daughter of so and so, in respect of property, undivided share and interest in the co-personal property of residential number. So, why it has been said, my lord? It's in the joint name, my lord, mother and daughter, my lord. It's in the name of mother and daughter, my lord. After expiration.
Please come to the order.
And my lord, the court come to conclusion that, my lord, the finding of the court, my lord.
Let us read the order from the reasoning part. Page number 27, please read.
On 29, my lord, starts from para 8, my lord.
No, let's read the brief facts. Page number 27, paragraph number 6.
The brief facts of the affidavit is that the petitioner seeking permission to sell the resident plot bearing number so and so, which is situated at Keshapur, Hubli. The said property is jointly held by Kumari Komal, daughter of Shankarasa, so and so, is just studying in 8th standard. The value of the said property is more than 1 crore, but the petitioner stated that she wished to alienate the said property just only for 24 lakhs, which is very low price. The petitioner, without there being any necessity to the minor child, tries to sell the same against the interest of the minor. Selling minor's property for low price is not the interest and welfare of the minor child, Komal. It is further submitted that there is an appeal before the Honorable High Court of Karnataka, so and so. If the petitioner succeeds in selling the said property, there is no source of income for the minor child, and the petitioner is staying in her parents' house. If she sold the said property, the minor's child will be suffer loss, and further there is no source of minor's education, etc., and trade to allow the application. The objection of the petitioner is that the suit property is a joint family property. The husband of the petitioner and the father of the minor late so and so acquired the suit property under register family partition deed dated 7/7/2012, registered before the senior sub register Ubadi. After register partition, the suit property was mutated in the name of deceased Shankar, who started residing separate with his family. After his death, the petitioner and her minor daughter have been residing with the petitioner parents, and the petitioner alone has taken care of the minor. After death of Sri Shankar, the name of the petitioner and her minor daughter were duly mutated in the revenue records as the joint owners of the suit property. The market value of the suit property is approximately 24 lakhs, and proposed sale is only for the bona fide necessity of the petitioner and minor as stated in the petition. It is further contended that the impleading applicant father-in-law has no right, title and interest in the suit property, nor does he derive any claim through the deceased or the minor. Therefore, he is not either necessary for nor proper party to the present proceedings. The scope of the proceedings under Guardians and Wards Act is limited to determining the welfare of the minor and guardian or refusing permission for the proposed sale. It does not involve adjudication of interstate property dispute with the applicant. The scope of the proceedings under Guardians and Wards Act is strictly limited to examining the welfare of the minor and considering whether the permission of sale should be granted. These proceedings do not involve adjudication of the property disputes between third parties or relatives. The impleading application appears to be only to delay and obstruct the present proceedings without any legal standing or bona fide reason. The application has no locus to interfere in the decisions concerning the minor's welfare. The impleading application wholly not maintainable and please,
I've seen, you can make your submission.
please. And the observation of the trial court. Next,
I have read the order.
next para.
I've read the entire order, you can make your submissions, I'm saying.
Now, father-in-law is not the class 1 here also at all also, my lord. It's a error, grave error finding, my lord. Under the section act, the father is not comes under the class 1 years also.
Here, father-in-law doesn't say he wants a property. What he says is, the property which is worth crores of rupees, you want to sell it for 25 lakhs. And other than this property, there is no property to the minor. Court only felt that court will not adjudicate any other rights, but it will only, he'll be assisting the court as the court exercises the parent patria jurisdiction. While deciding this, he will assess the court.
With a great respect, my lord, my respect to submission, my lord. With regard to this a special enactment has been enacted by the legislature. A procedure has been laid down, my lord. It is the discretion of the court, my lord. Whatever the documents which has been produced, the court has to examine, my lord, the provisions.
What is the prejudice that is caused to you?
Please.
What is the prejudice that is caused to you?
Now the finding is that, my lord, he is the class 1 here and he is want to do.
No, please read it. Close it. Though the petitioner is a natural guardian of the minor, the presence of the proposed party who is the paternal grandfather and the class 1 deceased would assist the court in effectively and completely adjudicating the real controversy, particularly with regard to the necessity of sale, adequacy of consideration, and safeguarding the minor's interest. That's it.
The act does not provide at all, my
Let it
lord.
not.
The act provides, my lord, certain procedure. Under 7, my lord, if the application has been filed, what is the procedure? And my lord, if your lordship see, my lord, kindly section 17, my lord.
You that section?
17, my lord.
Yes. Yes.
Matters to be considered by the court in appointing guardian. In appointing or declaring the guardian of the minor, the court shall, subject to the provisions of this section, be guardian what consistently with the law which the minor is subject appears in the circumstances to be for the welfare of the minor. In considering the what will be the for welfare of the minor, the court shall have regard to the age, sex, and religion of the minor, the character and the capacity of the proposed guardian, and his nearness kin to the minor, the wishes, if any, and his parents, and existing previous relations of the proposed guardian with the minor of his property.
Yes.
If the court minor is old enough to form an intelligent preference, the court may consider the provision. The court shall not appoint or declare any person to declare against guardian against his will. Then, my lord, section 29, my lord. Limitation of the powers of the guardian of the appointed and declared by the court, where a person other than the collector, the guardian appointed by will or other instrument has been appointed to be declared by the court to be a guardian of the property of the ward, he shall not, without previous permission of the court, mortgage or charge or transfer by sale, gift, exchange, otherwise any part of the immovable property of his lease, any part of that property from a term exceeding 5 years or from any term exceeding more than 1 year beyond the date of which the ward which will be the. So it is the special enactment which has been made, my lord. The mother is the natural guardian, my lord. my humble submission. I cannot deprive my daughter's right, my lord.
Yes. Please go. The present petition is filed agreed with the orders passed in I number 2 in JNWC number 206 of 2025, date 22nd January 2026. The petitioner herein has filed a petition under section 7 of the Guardians and Wards Act seeking a relief that she should be appointed as guardian to the property of the minor. Then the other relief is the court may be pleased to grant permission to sell the interest of the minor, undivided share and interest of the co-partnership property. In that, the paternal grandfather has filed an IA under Order 1 Rule 10. It is his case that the girl is studying 8th standard. The value of the property is more than 1 crore. But the mother stated that she wants to alienate the property just only for 24 lakhs, which is very low price. The petitioner, without there being any necessity to the minor child, tries to sell the same against the interest of the minor. Selling of minor's property for low price is not in the interest and welfare of the minor child. It is also the case that there is an appeal before the High Court of Karnataka, Dharwad bench, in respect to the very property in RFA number 100257 of 2020. If the mother succeeds in selling the property, there is no source of income for the minor child, and the mother is staying in her parents' house. If she sells the property, the minor child will suffer loss, and further, there is no source of the minor's education. The court, then the petition herein has filed the objection stating that in the guardian, in an application that's filed under Section 7 of the Guardianship and Wards Act, except the party, there are no other persons or necessary parties to the suit, and the same has to be dismissed. The court, by order impugned, had allowed the IA. The court observes that in proceedings seeking permission to alienate a minor's property, the paramount consideration of the court is the welfare and best interest of the minor. Any person who has direct and substantial interest in the estate from which the minor derives title and who raises bona fide concerns regarding the protecting of such interests cannot be said to be a stranger to the proceedings. Though the mother is a natural guardian of the minor, the presence of the proposed respondent, who is the paternal grandfather and class 1 legal heir of the deceased, would assist the court in effectively and completely adjudicating the real controversy, particularly with regard to the necessity of sale, adequacy of consideration, and safeguarding the minor's interests. The impleadment of the proposed respondent would not prejudice the petitioner, nor would it enlarge the scope of the proceedings beyond the statutory duty of the court under the Guardians and Wards Act. On the contrary, his presence would enable the court to arrive at a just decision after hearing all interested stakeholders, keeping the welfare of the minor at the forefront. Therefore, the court felt that the respondent grandfather is a proper and necessary party, and accordingly allowed the petition. Then counsel appearing for the petitioner mother submits that the order passed by the court by impleading the grandfather is contrary to the provisions of the act. He has drawn the attention of the court to section 17, which deals with matters to be considered by the court in appointing guardian. Then he has also drawn the attention of the court to 29. It is submitted that the mother, who is the natural guardian of the child, will not do anything which is not in the interest of the child. The inquiry under a petition that is filed under section 7 is limited, and the grandfather is not a proper and necessary party to this proceedings. The court can decide the dispute that is raised by the mother with regard to appointing her as guardian and selling the property of the guardian. Court would be deciding it basing on the material And for that purpose, the grandfather is not a necessary party, and that is beyond the purport of the, beyond the purport and beyond the provisions of the Act. Anything else to be added?
The finding legal errors, my lord, it's.
It is submitted that the court says he is a class 1 legal heir. Such a finding is in the facts and circumstances is unwarranted.
The acts itself is not under the schedule.
Unwarranted, and here the court is not deciding about any inter-se dispute between the family members.
Allah is not under, comes under class 1 heirs at all, under
She
succession act.
submitted that it doesn't even come under the class 1 heir. Next one. Having heard the land counts for the petitioner, peruse the material on record. The mother has filed an application to appoint her as a guardian to the property, and also she wants to sell the property. Father files father is no more. Grandfather files an application under Order 1 Rule 10 to implead himself. It is the contention of the grandfather that this is the only property left for the child. If this property is sold, she would be left with no other property. Further, the mother wants to sell this property for an amount of rupees 25 lakhs when the property in the vicinity is more than 1 crore rupees. Further, it is a case that an RFA is pending before the High Court. The court, while considering the application of the father, has observed that no doubt the mother is a natural guardian. The grandfather has placed before the facts in the interest of the minor. The presence of the grandfather will assist the court in coming to a just conclusion with regard to the selling of the property. While adjudicating any issue under Section 7 of the Act and while passing any of the orders, the paramount consideration of the court is the welfare of the child. The court, just because the natural guardian has filed a petition seeking a petition to sell the property, the court, basing on her submissions, would not be doing it. But there the court exercises the parent patriae jurisdiction, and looking at the welfare and in the interest of the child, the orders would be passed. Now, the grandfather being on record, it would be he would be assisting the court in a manner in a manner that is in the interest and welfare of the child. It is both the father and both the mother and the grandfather, both are seeing at the interest of the minor child. And the top of it, the courts also is looking at the welfare of the child. In these circumstances, no prejudice would be caused to the petitioner if the grandfather is impleaded as a party to these proceedings. Further, the court is not going to decide any issue that is pertaining to the property, any dispute between the mother and the grandfather. Even after the grandfather is impleaded, the only issue that would be decided is whether the property which the mother wants to sell, which belongs to the child, can be sold or not. That is in the welfare of the child. In the considered opinion of the court, in these circumstances, there is no illegality with the order. Accordingly, dismissed.
Please.
Number 70, Shivraj P. Mudhol.
Prepare for the petitioner. My lord, petitioner has challenged impugned order passed by the second respondent wide annexure of page 19, whereby the second respondent passed an order.
Yes.
Passed an order about holding that petitioner is ineligible to take a part in the election process as he has suffered disqualification under section.
Let us see who is the second respondent.
Second respondent is Joint Registrar of Cooperative Society. But the facts of the case is the petitioner is a chairman 2009 to 2020. He is a member. Annexure A is a document to show that he is 5 to 2020. He is served as a chairman of the society, third respondent society. Annexure A is presently issued by the third respondent society. He is an active member of the society.
The election is required to be conducted for the, after completion of the 2025, next 5 years, election is required to be conducted. The procedure contemplated under the Rule 13, 15 days prior to 6 months to the date of election, a notice was issued to the parties. Here, Rule 13D. Here, they have issued a notice recently calling upon, the society has issued a notice calling upon me, you are not eligible in view of that, you have not attended 3 annual general body meeting and not utilized service as contemplated under section 20, subclause 2, 4 and 5. I have submitted a reply that the annual general body meeting was not served on me.
What is that?
Annual general body meeting was not.
Fact remains is you have not attended the 3
Yes.
annual general body.
Yes, yes, ma'am. Then the society referred the matter to the competent authority, that is second respondent,
To find for what?
to consider the objection. My reply, show cause notice, I replied, the competent authority, the second respondent, to consider the objections of whether I am eligible to contest or not. The second respondent, the procedure, my lord, the procedure, my lord, Rule 13D, my lord,
No, once you have not attended the 3 annual consecutive general body meetings, you are not eligible to vote.
as and yes, my lord. The meeting of annual general meeting has to be served. Second,
Which provision deals with it?
my lord, page Rule 13D, Rule 13D 2A,
13.
13D 2A.
D.
Rule, please. 2A. Relevant is Roman 2, my lord. Made.
Oh, this is one aspect for the annual general body meeting.
Yes, ma'am.
What is, which provision is governed by that?
Rule provides Rule 14 provides that
Let's see that rule.
14 AJ.
14.
AJ. The ordinary, the chief executive after the 2, my lord, the chief executive after the board decides the date and time of the general meeting to be convened shall convene the annual general body meeting by giving a notice at least.
Notification of general election.
Please, ma'am.
Rule 14 deals with notification of general election.
Election.
No. Now the first issue is you have not attended the 3 the general body meeting.
Yes, ma'am.
According to you, no notice was served
Yes.
on you.
Yes, ma'am. Yes, ma'am.
First, that is the issue. Once you have not attended, you are not eligible.
Yes, ma'am.
As per the provision.
Yes, ma'am.
Your only submission is it is not served.
Not served.
So whenever a general body meeting has to be held, what is the procedure to be followed?
No, the notice has been sent to the parties.
But I want to see that. Where is the procedure contemplated?
14 AJ, general meeting, my lord.
14 AJ.
AJ. Lord,
Are you referring to the section or the rule?
Rule, my lord. Rule. AJ.
General meetings, 14
Yes,
AJ.
two, my lord. The chief executive, after the board decides the date and time of the general meeting of the to be convened, shall convene annual general meeting by giving a notice at least 15 clear days as specified by the bylaw. However, in the case of exigency, the special general meeting may be convened by giving a notice at least 10 clear days in writing. The notice may be sent in the following modes, namely ordinary post, email, local delivery, publication. But these are the criteria which not notice has been. But there is no single document to show that notice was been served on the petitioner. This is my submission. Second, my lord,
How did the first respondent, second respondent dealt with it?
please.
How did the second respondent dealt with that?
Second respondent says, my lord, the second respondent, my lord,
Page 20.
Page 20.
Relevant.
Nowhere, page 20, third para, my lord, he says, nowhere it says that notice has been served on me. What he says, meeting was conducted, members attended. No notice, my lord, specific case is not considered. It says, no,
Annual general meeting means that once in a year it will be held. Annual general body meeting is 1 year.
once in a 1 year.
So for 3 years, you were, just because you thought that for 3 years there is no meeting.
Yes. No, notice was not served. This is my contention. Notice was not served on.
Worked as a chairman of the
Earlier,
society for a long period of years.
Yes.
And you should know that there
Yes,
will be,
yes.
if really you are interested in the participation of the affairs of
Yes.
the society,
Yes.
3 long years is something.
Not,
Saying that no notice served
yes, not.
on.
However, my lord, this.
No, they will keep every record of notice, acknowledgement of every member.
Yes,
for
but
many years.
they should, they have to maintain the acknowledgement for having a served. But if
We'll ask, let
my lord, one more submission I'll make. The entire proceedings initiated by these my lord, authorities my lord, vitiated and illegal contrary to Rule 13D, Roman 2. Roman 2D, my lord, it says, I'll read, my lord. The chief executive of every cooperative society shall send the prepared notice to all ineligible members 15 days prior to 6 months to the date of election. Till today, date of election was not fixed. Voter list was not published. Provisional voter list was not published. They have to first fix the date of election prior to 6 months. Then 15 days, they have to issue notice in these proceedings. Here, this is only my lord.
Condition is to, my lords, 60 days notice has to be given prior to election, my lords. And it was given much earlier to that, even before.
The election date is fixed.
Not yet fixed, according to him.
And then why are you?
Then that condition will not be applicable for him also.
The proceedings not impugned order is vitiated. Now, the authority.
Your proceedings are, no, as far as the proceedings of the first and second respondent are concerned, about whether you are an eligible. Now, after all this, they will prepare the voters of.
Monday they will publish provisional and final voter list. Monday. My prayer is direct the second respondent to include the name of petitioner in the voter list. This is my. But this is violation of Rule 3D. Rule 3D, it says, my lord, the notice. Then my lord, this.
First of all, to declare you as an ineligible voter, the one thing is that there is you have not attended 3 consecutive annual meetings that you accept.
Yes.
That makes you ineligible. Next question is about notice.
Please.
According to you, notice. That itself is something which can't be believed that, for 3 years you have not attended because no notice is served.
Please. My lord, last submission is, my lord. The issue, my lord, already, my lord, the voters have, my lord, approached this honorable Annexure G, my lord, I produced, my lord. The violation of Rule 3.
Not, first of all, your primary contention is this. For the second step, we will go later.
Please.
Now, for the first step, let this.
Please.
Where is the society made a party?
No, respondent number 3 is a society.
Respondent number 3, come and tell the court.
Please.
The notice to 1, you take notice to 2 also.
1 and 2 also.
1, 2, and 3, my lord. The 3 is also.
Take 3.
Returning officer.
3 is, my lord. Baramgowda appears for, my lord.
1 and 2, so and so the HA takes notice. 3.
3 is, my lord, I pray for emergent.
So is directed to take notice.
And also, my lord, hand summons, my lord, I'll pray.
4, the petitioner is permitted to take out, in addition, petition is permitted to take out hand summons on 3 and 4. The petitioner serve the copy of the writ petition on the HA as well as the council.
Baramgowda appears for the respondent number 4.
This matter on 12th.
Please.
Yes, next.
Till number 18.
18.
Please. Petitioner is the land loser whose land was acquired and, my lord, the compensation is deposited before the LSC court. After, my lord, the reference court enhanced the compensation. Both the, my lord, claimant as well as the SLA are before this honorable court in appeal. Whereas I filed my appeal immediately in 2024. The SLA has filed, my lord, on 5/1/2026 and it is still not listed before this honorable court. But the amount was deposited much long ago before the LSC court after the award was passed. Now I sought, my lord, release of that amount by filing an application for payment. The, my lord, court rejects that application on the ground that, my lord, appeals are pending before this honorable court.
How can it be? You have sought for enhancement of the compensation.
Yes, my lord. Before this honorable court also I have sought for enhancement of the compensation.
No, there is
Now,
no
even
dispute. There is no dispute about the entitlement.
No, my land for acquired more 2017
Rival claims.
before, no, only one landholder. No. Other than me, there is no other person who is claiming.
Let us see.
Please,
Let us see.
yes, ma'am. The order,
Come to paragraph number 9,
impugned order, Manoj.
10, paragraph number 10. No, where is that? Your application, present order,
Present order, page number 43.
43. Yes, please read.
Shri so and so advocate petitioner claimant filed application dated so and so under section 151 CPC for payment of deposited amount of rupees 1,39,65,833 in favor of the claimant petitioner on the ground that there was no appeal or stay order pending case against the judgment and award passed in the case, hence praised to allow the application. Learned AGP for respondent opposed the application by filing written.
When was your appeal? When was their appeal?
My appeal, Manoj, I have filed in 2024.
Their appeal?
Their appeal filed on 5/1/2026 after a delay of more than 1.5 years. Manoj, the judgment in the LSC proceedings was passed on 19/3/2020.
Disputing the compensation that is recorded by the.
That is regarding, yes, they are not disputing the liability. Earlier, Manoj, the entire compensation that was awarded at the time, Manoj, by the SLO was, Manoj, 1 crore 60 lakhs.
We'll find out from them.
So, my lords may kindly see in the award itself, their own award, 1 crore 60 lakh is the undisputed amount that they have deposited. Now, reference court enhanced it to 24 lakhs per acre, my lords. I'll clarify, my lords, that point.
What is the extent acquired?
12 acres, 34 guntas.
12 acres, 34 guntas.
For that, my lord, SLO,
What was the rate fixed by the SLO?
total award passed was 1 crore 60 lakhs, 2,046 rupees for the entire 1 crore 60 lakhs.
That is enhanced to?
That is now enhanced to, my lord, 24 lakhs per acre.
It comes to?
It comes to, my lord, much more than, my lord, the market value would come to, my lord, around 5 crores.
Want to withdraw?
My market value would come to around 5 crores plus, my lord, 100% solution.
As per you say.
Now I want to withdraw this undisputed amount which they have deposited. Now out of this they have deposited 1 crore 39 lakh rupees before the.
So what's the difficulty to that?
Lords, the only.
So this will not be further reduced, my lord.
Only contention is that, my lords, the state has also filed appeal,
That is
seeking for reduction.
State is agreed by the enhancement.
Yes.
Enhanced amount is coming to 5 crores and odd.
Yes.
You are not agreed by what is fixed by the SLO. You only fixed.
Their only award.
So fixed it at 1 crore.
60 lakhs.
1 crore 60 lakhs. No, there can't be no. Your appeal won't be like the court will not reduce it beyond 1 crore 60 lakhs. So there can't be any reason for the court.
On Monday, my lords, I'll take it.
Monday.
I'll take notice for.
The so and so takes notice on behalf
Both
of
respondents.
Both the respondents, and we'll allow the writ petition on that day. Get instructions. Yes.
In preliminary hearing only.
That's a difficulty.
No, but small matters at least, my lord, they can be.
Listen, this we will reach. Let it be anywhere. Yes.
Please.
Yes, partner, with the evidence.
Petitioner in this matter, my lords.
Yes, sir.
My lords, ineligible voters are before this honorable court, my lords, seeking right to vote, my lord, direction by this honorable court to permit them to cast their vote. Annexure P244 page number may kindly be perused, my lords.
One thing I'm not able to understand, why eligible voters should be permitted to vote?
Lord,
There is some reason. First of all, you should, some arguable issue in this, you should bring to the notice of the court. Then basing on that, the court permitting you to vote is a different issue. So first of all, what is the infirmity with that order?
Please, my lords. Lord, wherein, my lord, the petitioners are the members of the society herein, my lord. Lord, they, my lords, on the reason that, my lord, they missed the 3 consecutive meetings, my lord, then hence, on that right, on particular that issue, my lord, the petitioners were included into non-eligible voters list, my lord.
That is a prerequisite.
Yes, please,
By
but
preparing the voters list, if you fail to.
but, my lord, the voter list has to prepare in accordance with the rules, my lord. In violation of that particular rules, my lord, the voter list is prepared, my lord. And this honorable court in the
Before that, you have to tell the court one.
Please.
Whether all these petitioners have attended the annual general body meeting for the last 3 years or not.
Our contention is that, my lord, no notice is served to this petitioner. Particular notice is required as per Rule 13D2.
Yes.
My lord, that is a disputed question of fact, my lord. This honorable court has no jurisdiction to adjudicate the
No,
disputed
but as
fact.
well, this is being
Allowed
done.
out.
These are all series of writ petitions.
Yes, my lord. My lord, for that reason, my lord, in this case is concerned, my lord. My lord, at the fag and I approached this honorable court and they have seeking the right.
When was this ineligible voters list is printed, published?
Please, my lords.
Date?
Moment.
Yes.
Please, my lords.
Nine one 2026.
Yes.
Please, my lords. 9/1/2026.
Then how do you call it last minute?
Please, my lord.
You say at the fag end. Where is the fag end?
My lord, 8/2/2026 is the date of election, my lord. Now, my lord, 8/2/2026.
That is true, but you have published the list on 9/1/2026.
My lord, that is the.
What is today?
My lord,
What
that
is the date? What is the date today?
My lord,
When did they file this writ petition?
My lords, on 5th February yesterday. My lord.
What were you doing from 9/1 to 4/2?
Some election procedure, my lords, collecting the all papers, my lords, and collecting, there are total, my lords, 188 members petitioners before this court, my
No,
lords.
step one.
Please.
Permit all of them to vote.
Please, my lords.
Step two, please, as already their votes have, they have, that also you please, along with that, the result should be announced. That would be the second order.
Lords, my contention before this court is that, my lord, if they are permitted to, my lord, cast their vote, my lord, for the reason, my lord, there are totally, my lords, n number of members before in the society, my lords, my kindly be perused, my lords, wherein, my lord, there are totally, my lord, 5,183 members, my lords. Out of that 5,183 members, my lord, 3,469 members are declared as ineligible voters, my lords.
Because you have not attended the meeting.
Lord, it will be on 60 to.
No, if you are declared as ineligible or
Please.
before that, in the other matter, I have seen that they have approached the joint registrar.
Please. But, my lord, with respect to very same society, my lord, this honorable court granted a order, my lord, my kind submission to this court, my lord. With respect to very same society in the very same election, my lords. Page 245 for a moment, my lord, may kindly peruse, my lords.
Now this here in this court, everything is done by the High Court only. Elections will be conducted contrary to the provisions. Yes.
My lord.
Similar orders are granted.
My lord, my submission. My lord, bank has prepared the writ appeal, my lord. Yesterday said writ appeal is disposed of, my lord. My lord, modifying the learned single judge order to the extent, my lord, 3 categories ballot box has to be prepared in respect of ineligible voters. They are kept in a separate sealed ballot box. My lord, one is the persons who are not attended the annual general meeting, and
Then
another.
what will you do later?
Again,
Keep it in a separate box.
The liberty is reserved in favor of the bank to contest the matter before the learned single judge. That is observed by the division bench of this honorable court yesterday, my lord. The order copy is not yet uploaded, but however, the government has taken the note of the fact, and the honorable court said that inform the returning officer. The order passed by the honorable court.
So now they also can vote. These people also can vote now.
Yes, in that term, because we pointed out that some of the petitioners who are not a member of the society, and some are the defaulters, and some who are not attended the annual general meeting, and some who are not qualified.
Now they will vote. After that, what will happen?
My lord, again they have to seek permission from this honorable court.
To declare the result.
How? Yes.
Now the court will say, you please count these votes also.
No, not like that. If this honorable court has.
First of all, you have to go to the root of the matter.
Yes.
Why all of them are before the court?
Yes.
What is to be
again,
done?
Section 70.
Without doing all that, every time election, why should the High Court interfere?
Yes, that is the legal position. Section 70 alternative remedy is available to the petitioners, but some matters, the honorable court exercising their discretion.
Their cases.
Yes, my lord.
Their cases.
Yes.
No notice is issued before the annual general body meeting is conducted.
Yes.
What is your response to that?
My lord, we have issued the notice.
Where is it?
My lord, we will produce. If they are.
If you produce, I will not permit them to vote.
My lord, yesterday they have filed the matter, my lord. Today I am appearing in the matter.
When are the elections?
Please,
when is the election?
8/2/2026.
February.
My lord, day after tomorrow, Sunday. I informed the bank, my lord.
I will list this matter on Tuesday. By Tuesday, like how the division bench said, keep a separate box.
Yes.
And if you place before the court to show that a notice is served on them, then on the same day, I will dismiss the writ petition that it is their ineligible voters. Their votes need not be counted.
Please.
The writ petitions are filed. The present writ petition is filed stating that the respondents have declared that the petitioners are ineligible voters as they have not attended the 3 consecutive annual general body meeting.
Now it is amended as 2.
Two consecutive general body meetings. It is the submission of the land counsel to the petitioner that no notice is issued to them. And as Rule 13J,
14 AJ.
14 AJ contemplates notice, and no such notice is issued to the petitioner. As such, they could not appear before they could not attend the meeting.
13(2)D, Lord. 13(2)D. Both notices. 13(2)D.
13(2)D and 14
AJ.
is annual general body meeting.
That's what I'm referring to, annual general body meeting only. 14 AJ contemplates notice to the members. It is submitted that the notice is not issued, they have not attended. It is submitted by the land counsel appearing for the petitioner as well as the land counsel for the respondent. In these kind of, in these similar matters, when an order was passed by a learned single judge, the same against that an appeal is filed. In the appeal is disposed of, directing the returning officer to keep 3 different ballots for boxes for the eligible, ineligible, and what is the third one?
The person who has attended the annual general, not attended
No,
the
lords.
annual general meeting, defaulters,
First defaulters.
and the person who is not having minimum transaction. 3 categories.
Asked to keep 3 ballot, the 3 boxes. One is for the defaulters.
Please.
Number 2, who have not attended the meeting.
Yes.
2 consecutive general body meetings. 3 is
The defaulters. The minimum transaction. The person who has not availed the minimum transaction.
3rd is the person who has not availed the minimum transaction. And the matter was remanded back to the learned single judge. Considering this court is passing the following order. As per the order passed in writ appeal number, give the number, so and so, write on paper and give. Writ appeal number, so and so, dated so and so. The respondent shall keep, the returning officer is directed to keep 3 boxes, like how it is said, 1 for that, 1 for this, so 2. Number 2, and the petitioners shall be permitted to vote. Number 3, the respondent, which respondent you are?
Respondent number 7.
7.
Yes.
Respondent number 7 shall place the material before this court to show whether the notice is served on the petitioners before the general body meeting is conducted as contemplated under Rule 14AJ of the Cooperative Societies Act.
Rules.
Cooperative Societies Rules. Does this matter?
One more submission, Lords.
On 1 minute, this is matter on 11th.
Please.
Almost on the respondent number, returning officer may kindly be directed to issue the identity cards immediately, my lord. In earlier elections, my lord, what they happened?
They are doing.
All the respondents shall take necessary steps to implement the order of this court and facilitate the petitioners to cast their vote.
Please.
The division bench also directed the bank to coordinate with the returning officer with regard to the classification of the petitioners. That
is there?
Please.
May I request my hand delivery of the order, my lords.
Hand delivery.
Please, my lords.
Please.
Take notice for R1 to R5, my lord. Take notice for R1 to R5.
AGA takes notice to
R1 to R5.
R1 to R5. Yes. Next.
Orders met. Seal number 20.
Yes,
Ahmad Ali Ji, Rahman Shah.
I appear for respond number 3, my lord.
Tale.
the process shall be filed for issuance of notice to R7 and R7. R7 within a period of 1 week, or else the writ petition shall stand dismissed against R7. Yes, 21.
Seal number 21. VM Chauhan.
This also R1, R3, R4 and R5, a week's time, or else appeal, writ petition shall stand dismissed. Yes,
Seal number
22.
22. Non-compliant.
In this case, my lords, I undertake to file wakalat on behalf of the respondent bank, my lords.
To move the memo,
Please, my lords. My lords, the reason is that, my lords, they are challenging the recovery proceedings and notice issued and auction notice issued under Surface Act, my lords.
there is
That has become infructuous, my lords.
that's right. There is no representation on behalf of the petitioner. This is matter for dismissal on Tuesday. Tuesday will pass out.
Please, my lords.
Then counsel for the respondent submits that the writ petition has become infructuous as auction is already conducted or not conducted.
Auction has deferred, my lords. Thereafter, the bank has withdrawn the earlier notices and subsequent notices were challenged in the SA proceedings and that came to be dismissed, my lords.
That in his presence will pass the order.
Please, my lords. My name may be shown for the respondent bank, my lords.
So and so, it is submitted that the auction, which is questioned, notification, which is questioned before this court is deferred. Thereafter, when the subsequent notices are issued, the petitioners have questioned the same by filing the essay.
SA, my lords. That came to be dismissed.
That also came to be dismissed.
Please.
Yes, next.
Much obliged.
Number 23. Chana Makdum.
The council on record is not well, my lords.
What counsel?
The council on record is not well, my lords. I request 12 minutes.
Well, my lords, in the meanwhile, the memo is filed by my lords, the petitioner, seeking deletion of my lords, respondent by 8 from the array of the parties, since he is also deleted before the trial court.
A memo is filed seeking deletion of R8 from the array of parties as he was deleted from the, even before the court accordingly. What is this memo for deletion? As per order dated 30/10.
He was not being served, so my lords,
No, it says order dated 30/10. What is the order dated 30/10? Where is the order?
it was by the registry, I believe, my lords.
Let me just look at it.
It was before the learned, before the honorable registrar, my lords. ARJ. He was not being served, my lords, and then.
The R8 is dead and praise time to file the necessary memo for deletion of the name.
Please.
The memo is filed accordingly. The R8 should be deleted from the array of petitioners and the cost title shall be filed. Yes.
May I request for a date, my lords, on the.
12.
Highly obliged, grateful.
24.
Seal number 24. Sadiq and Kanvi.
My lords, in this case,
Who filed the vacate stay?
Lord Khan.
You filed the vacate stay?
I am for the respond number 1 and 2.
lords, I am ready to argue on main matter, my lords. It consists only 2 points, my lords. Herein also, the order is passed by the board is not board, it is chief executive officer, and that is without jurisdiction. And the second is that no notice is issued as contemplated on section 64 clause 3 of the act, my lords. And my lords, in the previous date of hearing,
It is a case of Mutawalli being suspended.
yes,
Case of no confidence against the office bearers of the management of the work institution.
No, his contention is, this order is passed with the
Yes.
chief elected,
Board, executive board.
no, my lords, it is not board, it is chief executive officer under the delegation.
Let him make submissions. I'll clarify. my lord.
Please come to the order.
Page number 36, annexure F, my lords.
36. Additional chief executive officer.
Lords, before that, this order is issued under delegation of powers by the order number so and so.
No, it is by order of the board, additional chief executive officer has passed.
Yes, yes.
So that is the power is delegated to the chief executive officer. This, under which provision this order is passed?
Under the
64, my lords.
64.
64.
Yes, let's see. Yes.
Removal of Mutwalli, my lords.
Hmm.
Notwithstanding anything contained in this act, in this other law or the deed of work, the board may remove a Mutwalli from his office in his such Mutwalli so and so.
Then there is another provision where this
32, my lords.
30,
32 2G.
32 2G, wherein to appoint and remove the Mutwallis in accordance with law. This power is rest with the board itself, my lords, and this power cannot be delegated in view of.
let me read again. 32 2G.
Yes, my lords.
Where do you get that?
Functions
To
of the board.
appoint, these are the functions which can't be delegated. To appoint and remove Mutawallis in accordance with the provisions of the act.
Section 27 speaks that this, section 27 speaks that this power cannot be delegated.
Let's see that.
Section 27.
Powers by the board.
Yes, my lords.
The board may by general or so and so, as may be specified, except the powers and functions of the board mentioned under clause. So according to you, it falls under 60G.
Yes. So now the order is without jurisdiction, lords. Second point is, if the additional chief executive officer exercising the power under section 64, it is delegated to him, then also, my lords, he has to follow the procedure. That procedure is contemplated under form number rule 58, my lords. Rule 58, rules, my lords.
Yes.
Rule 58 speaks about procedure regarding removal of a Mutwalli. The chief executive officer shall issue a notice in the form 50 to the Mutwalli concerning against whom action is contemplated under section 64.
No notice is given to you.
No notice is given to me. And this is the requirement of section 64 also. Rule 58. Next, my lords, the board shall, the board shall conduct summary inquiry in the manner prescribed under rule 2 clause 50. Notes that rule clause 2 clause 50 states oral and documentary evidence and speaking order. Rule 50, my lords, clause 2.
Yes, let us look at manner inquiry.
Yes.
To be held by the chief executive officer. And
Clause 2 is only applicable, my lords, herein. The chief executive officer shall then proceed to hold a summary inquiry after considering the oral and documentary evidence.
So now, as per this, chief executive officer can conduct the inquiry.
No, my lords. The manner they are saying that in what manner the inquiry has to be conducted. It has to be conducted by the board only, but in the manner prescribed under Rule 50, Clause 2. The manner is that to take the oral and documentary evidence and pass the speaking order.
Oh, understood.
Yes, my lords. Now, what is form number 50, my lords? Form number 50 is a clear notice. Form number 50, in accordance 50 clause 1, my lords, notice to the Mutwalli secretary for so and so, section 64, my lords. Form number 51 is also another second notice. If I being suspended during the pendency of the inquiry, then I must get a notice that under section form number 51, that is rule 58 clause 3 notice must be given. No notice is given herein. My lords, this point I have argued during the last hearing, my lords, on the day 21/11/2025. The Learned Counsel appearing for the board has submitted that we have passed a separate order that I will produce. That you can produce the order.
Order sheet.
Of this honorable court. Dated 21/11/2025. Notes. Shri D.L. Ladkhan, Learned Counsel, seeks time to produce the order of the board which led to the passage of the impugned order. So it is admitted fact that, my lords, this is.
No. Which is that? Which order dated?
Order dated 21/11/2025.
21/11/2025.
Yes, Sri Ladkhan at that time, my lords, he represented to the board. He is a penal advocate.
So and so submits that the earlier committee is still attempting to issue tender notifications, or otherwise it was stated.
And that is my submission, my lord, because this honorable court granted interim order on 30th of the December. On 29th, my lord, we had already taken charge. Despite that, my lord, they had continued to, my lord, issue checks and do call for tenders and other things. I had produced
You
documents.
are the new committee.
I am the new committee.
What is the interim order?
Interim order was earlier granted stay of, my lord, that order passed, impugned order. Then it is modified, taking note of the fact that, my lord, we have already taken charge. So as on today, it stands at that place. We are in, my lord, the office since last 2 to 3 months now.
Let it stand, my lords. And it is subject to outcome of the writ petition. That does not bind the court's hands, my lords. Now, the Learned Counsel appearing for the board has made clear submission that there is another order which is passed by the board that he is going to submit. He is submitting since from 2 months and 16 days today.
Who appears for the?
My learned senior appearance.
Earlier advocate, some other advocate was appearing.
My lords,
Some other advocate was appearing. My lord, I was not aware of that or the submission made by him.
No, you don't appear now.
I am now appearing.
So,
My lord,
what do you say about his submissions?
Well,
His submission is twofold.
Yes.
One is with regard to the power of the board,
Yes.
power of the chief executive officer passing this order
Yes.
in the light of the bar under so and so.
Yes.
That such a power cannot be delegated to the chief executive officer by the board. Then he is entitled for notice. So on these counts, what is your submission?
So far as, my lord, the delegation is concerned, my lord, there is the board meeting, my lord, it is held that, my lord, the power has been delegated in favor of chief executive.
No, board, it is not about they doing it, whether they are competent to do under the act
itself.
permit them.
Yes. I
P 65, what is that, 35 G?
27, my lords.
27.
Under section 27, delegation of power, my lords.
No, G, what is that, 65 G?
32G can't be delegated is said by 27. 27 says 32 power function under 32G.
Yes. So that can't be delegated. What can't be done? The board cannot do it. If it does, it has to be set aside. Number two is about the notice, whether the notice is issued to him or not.
The notice, my lord, in fact, what happened, my lord, they have, my lord, no confidence.
Why are we going on with this oral arguments? Why don't the board file the objections?
May I just clarify with one statement, my lord? Whether these provisions are applicable or not, my lord, whether the court has to delve deeper into these aspects or not, I'll just clarify. But he is not a Mutwalli.
My lords, I am a Mutwalli, my lords, in view of the impugned
I
order.
was
my lords.
quiet when my
Strong
learned
objection,
friend
my
was
lords.
making
Existing members, my
submissions.
lords.
I was quiet when my learned friend was making. Let him be also quiet so that I can clarify. Further, if it is required, let him say.
Please.
We have 15 members were elected, my lord. A board of management of a work institution. Out of them, my lord, the office bearers are elected. They were the elected members. This pertains to a motion of no confidence. Entire work fact, my lord, does not have provisions regarding motion of no confidence. It is the, my lord, local, my lord, the institutions, they exercise these powers. They were present when the meeting was held. 9 members voted against them, against the existing office bearers. And they were resolution. We called for the meeting. Since the president, my lord, for last 2 years had not called for any meeting, no audit was conducted, no accounts were submitted, nothing regarding the expenditure of the work for placed before the board or the general public. Everyone was agreed. We called for a meeting saying that we don't have confidence in the president, vice president and other office bearers. So they attended the meeting. Then, my lord, 9 members voted against them. And they voted in our favor to choose us as the office bearers. Now, this is not an order per se, passed under either section 64 or 32G to inquire into him and then remove him, my lord. Because if they had been appointed by virtue of those orders, then, my lord, the question comes. Now, this is a no confidence motion. Order is only, my lord, of approval. We sent this resolution to the district work officer, who is the jurisdictional, my lord, head of the work institutions. He forwarded to the chief executive officer of the board. Board has approved it. And now this writ petition, my lord, has to be first
Approved. Chief executive officer has approved it.
Yes.
The consequences of a no confidence motion is what?
No, president and office bearers have to be removed.
Are removed.
Yes, yes.
So
No, that is not an inquiry as contemplated under my lord.
Inquiry, if that is so,
64.
who has to question it? Who has to sign it, approve it?
No, my lord, that's what it is forwarded to the district work officer. He in turn forwards it to the board. Board approves it. It is not passing an order, my lord, by holding an inquiry.
Please understand, whatever that has to be done directly or indirectly.
Yes, yes, no, no.
What is the effect of it? Ultimately, that has to be accepted by the board.
Exactly.
Which the board has not done it. It is done by the chief executive officer.
No, board is represented by chief executive officer. Board and chief executive, they are the same.
And the consequences of that acceptance amounts to removing of a.
So this is one submission. Now, primary submission, because only for the purpose of clarification I submitted. Before this, my lord, there are 2 more submissions. Writ petition is not maintainable. Any order passed by the board is to be challenged before the tribunal under section 83(2). There is a clear cut bar and.
Board has not passed it.
No, my lord. That is also a ground to be challenged before the.
When an order passed which is without jurisdiction.
No, that is also, my lord, to be challenged before the.
Maintainability of the writ petition.
No, that is one aspect. Secondly, writ petition has to be dismissed for the purpose of, my lord, suppression of facts. Now, what they do is, my lord, they produce that resolution, only half of it, saying that we did not attend. I have, along with my vacating stay application.
Say so that you didn't attend.
Yes, my lord. He said, no, the very purpose of him saying that no notice is issued to me is that when he attends the meeting.
Let us come to the writ petition.
When he attends the meeting.
Where is that that ever meant in the
Yes,
petition.
madam.
My lords, I am saying about notice that must be issued by the board.
Let's see, what
Yes,
did you say?
yes, please, my
It will
lords.
be clear once we look at it.
Please, my lords.
Paragraph number 4 onwards, my lord, it is regarding this motion of no confidence. May I read, my lord? 5, a meeting was convened on so and so with formal agenda. However, no issues listed in the agenda were discussed during meeting. Resolution dated 36/2005 was passed, signed by 4 to 7 along with committee members. Now, this resolution may kindly be seen.
No, where did he say that? You please point out that he was not present in the meeting.
No, that's what he said, my lord. For that purpose, he said no notice is issued to me.
Where is it? Please read it.
No, no, what I said is, my lord, he was present in the meeting. He produces.
Saying, you say he is present in the meeting, but he's saying that.
No,
as
what
it
I am
is
saying
not-
is, despite him being present in the meeting and being aware of what was done in the meeting, he tries to portray before this honorable court. That's why the document may kindly be seen. He produces more portion of that resolution, portion of that agenda. He does not want to disclose before this honorable court that in fact no confidence meeting was. If he had come before this honorable court saying that,
This, the issues which are listed in the agenda were
yes,
discussed.
were not discussed. That's why the document may kindly be seen, produced by him in the petition. Annexure D, my lords. Page number 27, if it is not later on corrected, my lords.
I think this aspect we don't have to look into, so please.
No, it has
note-
to be, because my lord, suppression is, my lord, one aspect, as my lords are aware, my lord, if he wants to seek a relief before this honorable court, he has to come with utmost clean hands. But he produces only a part of that resolution. One single page he produces, page number 27. This is in Kannada, but I'll, for my lord's purpose, my lord, I'll read it. There, serial number 4, my lords, may kind.
Let him come up with the council appearing for, what is which respondent?
Respondent number 1 and 2, my lord, if I'm not.
Respondent and 1 and 2 shall place before the court their objections by the next date of hearing, list on 19th of February.
My lords, since from 11th month of last year, my lords, they are taking, because of this modification of the order, they are, my lords, they are creating the hurdle in the.
That order is not
management,
The
my lords.
matter on, because that can't be before that date.
My lords, I am with the proceedings copy, my lords, how proceedings has been conducted, my lords. I have obtained the certified copy, my lords.
It doesn't matter, we'll hear on that day. Yes, 19, next.
Please.
Number 25,
Give that.
Raj.
Memo is filed seeking to withdraw the writ petition.
Limraj Muradi.
It is stated that the petition is not interested to prosecute the matter. Accordingly, memo is taken on record and dismissed as withdrawn. Yes, 26.
Still number 26. Still number 26.
No representation.
Raj.
posted.
My lord, in this matter, I undertake to appear on behalf of respondent number 6. Today only, my lord, they have served the copy on me.
Instructions to appear on behalf of so and so. The petition should serve the copy of the writ petition.
Please.
No representation, post after 4 weeks.
Please.
Yes, 27.
Still number 27. Srinivas Binay.
Yes.
The pleading applicants.
Nomination of the petitioners, Lord, have been rejected by the returning officer.
Yes.
On the count that, Lord, there is some, Lord, mistake in the signature, and Lord, this caste certificate is not been attached to the nomination. Lordship would find it place at, Lord, page
Wrongly posted.
26.
Why? Oh. By mistake, they have sent you a file to the section or to the chamber.
Yeah.
Well, any urgency for this?
No.
This is matter after 3 weeks.
Not urgency is with respect to, we are the impleading applicants in this matter. Wherein, my lords, we have been unanimously elected, my lords.
No, the file is not there. If you say there is urgency, I'll give some other date. Or else it will come after 3 weeks.
Next week, my lord, any date may be fixed.
Yes, next week. This is a matter on 19th.
Please.
Yes, next.
Great.
Admission matter, still number 28. Rishas Maigu.
Only
Shashank.
disability and no amenities is awarded and laid up.
Every matter of yours, why it should be decided in an admission stage. It's a 2025 matter.
Short, otherwise,
Everybody has a short issue, but we can't decide everything finally.
please.
Who appears?
I'm appearing for respondent number 2, my lords.
Yes. Are you ready?
Please, madam.
Where is the table?
My lords, kindly, page number, my lords, 22.
What are the injuries?
My lords, fracture middle one-third of left clavicle bone, my lords.
Hmm.
Towards pain and suffering, 20,000 is awarded.
Only one fracture.
One fracture, ma'am.
40,000 under the head of pain and suffering.
Please.
How many days he was in
Eight,
hospital?
8 days, my lords.
Incidental expenses rightly awarded.
And no amenities is awarded.
Medical, come to the table at page 22.
My lords,
Medical expenses as it is.
correct,
We will go in the same pattern, look at it.
correct,
35,571.
please.
Then why again to food and nourishment another 5,000? It should have been should have been the only 8,000.
And income due to disability, doctor stated 30%.
Loss of income due to disability. What is the evidence of the doctor?
30%, my lords.
Huh?
30%,
What, how much is taken by the board?
7%.
We'll take 10%.
Please, madam.
What is the, which year is the accident?
24, 15,750, my lords.
24.
Please.
How much is the amount?
15,750.
15,750. What is the multiplier?
13, my lords.
13 into
10.
10 by 100.
2,45,700. 15,750 into 12 into 13 into 10% disability, 2,45,700.
It comes to
45,700.
45,700.
And no amenities is awarded.
Will grant loss of income during laid up period.
Usually, my lords,
It is 15,750 into 3.
please.
Come to 47,250. Loss of amenities 20,000. Legal expenses 10,000. Any future medical expenses? Is
No,
not-
no, no.
It's coming to 4,11,521. Please come. Agreed with the award passed in MBC number 1842 of 2024. Dated 16th of May 2025. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at page 22. Land counsel appearing for the appellant submits that when the evidence of the doctor that he has suffered 30% disability to the limb, court ought to have taken 10%, but the court had taken 7% as a disability. It is submitted that even under the other heads also, the amount of compensation that is awarded is not just unreasonable. Land counsel appearing for the insurance company submits that insurance as the tribunal has rightly considered and granted compensation, and there are no grounds to interfere. Next, having heard so and so. The petition has sustained one fracture injury. Under the head of pain and suffering, this court is granting 40,000 towards inpatient charges and food and nourishment, court and medical expenses. Court had rightly granted the compensation, and this court finds no reasons to interfere. Then coming to the loss of income due to disability, when the doctor has reported that it is 30% disability to the limb, the court ought to have taken 10%, but without any basis, court had taken the income at 7%. Hence, this court is inclined to take the disability at 10%. 15,750 into 12 into 13 into 10 by 100 is 2,45,700. Coming to the loss of income during the later period, considering the disability of 12%, 10%, and the injuries under the head of loss of income during the lead-up period for 3 months, this court is granting 47,250. Coming to the loss of amenities, 20,000. In the light of the law laid down in vehicle houses so-and-so, legal expenses,
Pain
10,000.
and suffering 25,000. Pain and suffering 25,000, my lords, 40,000.
One fracture injury, the rule is 40,000. Addition to that, for every injury, 10,000. Legal expenses, 10,000. Altogether, the claimant is entitled for 4,11,521. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,72,061, 051 or 61, 061 to 4,11,521. Enhanced amount shall carry 6% interest.
Number 30,
Yes.
29.
Please, appear for the respondent number 1.
It's the petitioner is my lords, the mother of respondent number 1. It's after death of my lords, her husband, all these.
Family court matter.
No, my lords, it is my
Senior
lords,
citizen.
senior
Civil.
citizen. Please. It's after death of my lords, her husband, all the children, my lords, they have distributed my lords, the properties left behind by my lords, the husband of the petitioner. And my lords, one property, house property, that was my lords given to my lords, the petitioner, by all the my lords, the children, by executing my lords a release deed, which is annexary.
Here is the mother.
She is the mother. One property is given to her, residential house. Thereafterwards, my lords,
She offered?
release deed, relinquishment deed. Thereafterwards, my lords, the first respondent, my lords, wanted my lords, the mother to stand as my lords, a security for a loan, my lords, he is taking from the bank for his business purpose. My lords, the mother has stood as my lords, the surety and offered my lords this property as my lords, security to my lords, the loan taken by my lords, her son, that is respondent number 1. Thereafterwards, my lords, he did not repay my lords, the loan amount. The bank started my lords, recovery proceedings. One of the option is for my lords, auction of my lords, the subject property for a throwaway price. Thereafterwards, my lords, the petitioner, after coming to know that, my lords, she, my lords, entered into an agreement of sale with a third party to, my lords, save, my lords, the residential house. And, my lords, she has taken earnest money and paid it to, my lords, the banker. And, my lords, the auction sale was avoided for the time being. Thereafterwards, the son, my lords, first respondent, he has, my lords, entered into, my lords, the residential house and started living there. Now, my lords, I am in a situation where, my lords, I have paid the money by, my lords, executing a sale agreement in favor of, my lords, some third party by receiving, my lords, the earnest money and paid it to the bank. On the other hand, the son now, my lords, he is not ready and allowing me, my lords, to sell the property, to repay, my lords, the entire loan amount and keep, my lords, some amount for my future life. Now, my lords, I have approached, my lords, the assistant commissioner at the first instance. Assistant commissioner passed an order of eviction, directing him to, my lords, vacate, my lords, the residential house. My lords, he approached, my lords, the deputy commissioner in appeal. The deputy commissioner now, my lords, passed an order saying that, my lords, it is a civil dispute between, my lords, the mother and, my lords, the son.
Look at the provisions of the act.
My lords, Section 23. And directed, my lords, the petitioner to approach the civil court.
What are the disputes that can be decided by the court? Let's see. Under this act.
Please.
Section
23, my lords, it speaks about, my lords, the transfer of, my lords, the property.
Let's read 23.
Please. Where any senior citizen who, after commencement of this act, has transferred by way of gift or otherwise his property subject to the condition that the transferee shall provide basic amenity and basic physical needs to the transferor, and such transferee refuse, my lords, it speaks about, my lords, only transfer. Whereas, my lords, the interpretation of this provision, my lords, this honorable court says that, my lords, it includes.
Take the judgment.
Para 12.
Yes.
It includes, my lords, the handing over of, my lords,
Yeah. Para 9, let's read from para 9.
please. I have considered the submission on both the sides and have produced the records. Our society is a traditional society and its core value is to provide care for the elderly, and the relevant portion is, my lords, para 12, my lords, where, my lords, the court says that, my lords, the court can order for, my lords, possession of, my lords, the property in favor of, my lords, the elderly persons. May I read, please?
Yes, what do you say?
Please, Your Lordship. What has happened in present case, Your Lordship? The father of the respondent number 1, Your Lordship, sir, it's a joint family property, Your Lordship, sir. After the death of the respondent number respondent number 1's father, Your Lordship, sir, all the family members, including the petitioners and two sister and a younger brother, became the co-partners of the property, Your Lordship, sir. After the death of the father of the respondent number 1, Your Lordship, sir, before his death, Your Lordship, sorry, Your Lordship, before this death, Your Lordship, there was an intention of his father that the present disputed property would be given to him, Your Lordship, as the property bearing number RS 6 plus 6 plus 618, 2 guntas, measuring 2 guntas, 2 annas was given in favor of the sister, Your Lordship, and a flat bearing number 3052 of at a prestigious Kistan apartment in Bangalore, Your Lordship, was purchased in the name of the sister, Your Lordship, of the respondent number 1 during his lifetime, Your Lordship. Thereafter, Your Lordship, RS number 611D, the house property 49 measuring 1 guntas 13 annas was situated in the Nehru Nagar, Hubli, was purchased in the name of the present petitioner here in, Your Lordship, and that is not in a disputed question, Your Lordship. And RS number 6 RS number 611
All that are not
A.
necessary. All that are not necessary. Please
Please.
tell the court whether that all the family members have relinquished their right in
Please.
respect of that property to the
I'll
petitioner or not.
I'll come to that point, Your Lordship,
First
sir.
come to that.
Please,
Whether
Your
it is
Lordship.
relinquished or not.
Please, Your Lordship. What has happened is, Your Lordship, sir, after the death of the father of the respondent number 1, Your Lordship, sir, all the family members gathered together, Your Lordship, sir. Thereafter, Your Lordship, they come to a decision that the property bearing the subject disputed property will be given to the present respondent number 1, Your Lordship, and the RS number 611A, plot number 10 and 12, measuring 1 guntas 8 annas each, Your Lordship, will be given to the brother of the respondent number 1, Your Lordship. Thereafter, Your Lordship, fraudulently, Your Lordship, the release deed came to be executed by misrepresentation to avoid the tax and the loan dues, Your Lordship. The mother of the respondent number 1, Your Lordship, fraudulently executed the release deed, Your Lordship, in favor of her, Your Lordship. And it was after it was the post dismissal of the father, Your Lordship, in order to avoid the taxation, Your Lordship, it was done, Your Lordship. The death of the mother, Your Lordship, after the death of the father, Your Lordship, the another property was also purchased in the name of the.
Who is Mallikarjuna Swami Bihiremath?
Your Lordship,
You are
my-
your senior.
Please, Your Lordship. Please, Your
Name
Lordship.
is Mallikarjuna.
No, Your Lordship, my senior.
Ask your senior to come. Yes, this is matter. Wednesday.
Date, my dear.
Wednesday.
Please.
Yes.
Seal number 30.
I seek apology,
Yeah,
Your
number
Lordship. It's a matter, Your Lordship, wherein the OS is also pending, Your Lordship,
Let us say,
sir.
ask your senior to come.
Please, Your Lordship, sir.
Yes.
Pass over, Your Lordship, my senior will appear. Your Lordship.
Today I'm not sitting in the afternoon. Yes. 30.
And the act relied, Your Lordship, section 3 doesn't apply to case in hand also, Your
What will
Lordship.
see Mr. Council, ask him to come. Yes, 30.
Seal number 30.
30.
My lords, I'm sorry, it is my personal case. I have filed a case against the state. I could not appear in this case. Kindly have 10 minutes. Next week, next Thursday or Friday.
He submitted that the AGA has filed this petition now as he's appointed as AGA. He wants to, they'll give up the wakalat. Let's just matter after 2 weeks.
Sorry, my lord.
And she will
Sorry,
appear.
my lord. Next week, Monday, my lord.
My lords,
How is it possible by Monday to give up the
I will
wakalat?
show the name of Srimati Reshma. Show the name, her name may be.
My name is there in the wakalat.
Already there, Raishma Madiulwar.
Yes, my lord.
She's already appearing.
Please.
Then delete the name of Mr. T.
Hanum
Reddy. List this matter after 2 weeks. Next week. Yes, 31.
Seal number 31. Vishwanath Bhatt.
Yes, it will come. 31.
Seal number 31. Vishwanath Bhatt. GB Baramgowda, AGA.
And appears after 4 weeks. Yes, 37, 32.
4 weeks. Seal number 32. Sirajuddin Ahmad.
Parole case. Parole case.
Sirajuddin Ahmad.
Yes.
The petitioner is the father of the convict, my lords. He has filed an application seeking grant of parole for the son, my lords, who is undergoing sentence for life imprisonment and 302, my lords. The reason for the parole is, my lords, the medical certificate is annexed at annexure A, page number 18, my lords. Page number 18. The mother of the convict, Savitri, my lords, is aged about 60 years. She is suffering from cervical lumbar spondylosis. To take care of the son is required for at this stage, my lords. Hence, the father of the convict has sought for parole.
Similar matter, my lords.
Where is that prayer in the writ petition?
Please.
Prayer in the writ petition is at, my lords, page number
Direct the
14.
respondent number 2 to release the petitioner's son. Please go before the respondent number 2. He will consider your case.
My lords, already we are given representation, my lords.
That he will consider. The present writ petition is filed seeking the following prayer. The petitioner is seeking parole from this court. This court in writ petition number so and so has passed the following order. In the light of the same, the petitioner shall approach shall give a representation to the superintendent Central Prison Dharwad, and he shall consider the same in accordance with law within a period of 8 weeks from the date of receipt of the copy of this order.
Seal number 33.
My lords, my humble submission is that my lords, already a representation has been given, my lords. Based on that representation, the police report they rejected, my lords. My lords, representation 14/8/2025, my lords.
If it rejected, where is that order? That order you need to challenge.
Yeah, my lords, they have not rejected, my lords. Only they have forwarded the.
That's what the.
Based on that,
what
they
is
have
the
rejected, my
representation
lords.
dated?
My lords, application dated 28/7/2025, my lords, and the police report is 14/8/2025, my lords.
They have already given a representation dated 28/7/2025 to the second respondent. The second respondent shall consider the same in accordance with law within a period of 8 weeks. Yes. Next.
Number 33.
This serial number 33, my lordship. I have challenged the order in the order passed in MA, my lordship.
Counsel for the respondent.
CS Shutter.
No representation for the respondent. List is matter after 3 weeks.
There is an interim order, my lordship. Interim order.
All granted is extended.
Grateful, my lordship.
Seal number 34. Chetan Munwadi.
Therefore, petitioner.
Today I am appearing for the respondent institution, my lord, third respondent. I pray for 2 weeks time, my lord. Today I have received instructions. My lord, he is unauthorizedly absent after reporting for duty on reinstatement. He was reinstated, my lord, after suspension. That was on 28/10/2024, my lord. Petitioner has reported. Then thereafter, my lord, he has never worked in the institution. He remained unauthorizedly absent. Several notices are issued and he did not reply. And for one notice, he says that, my lord, he is asking to close the inquiry.
The relief that is sought is directing respondent number 2 to consider the written statement dated 30/5/2025 and direct the respondent to pass orders in the disciplinary proceedings. What has happened to the disciplinary proceedings?
My lord, the articles of charges are framed. Notice was issued. Thereafter, he has submitted his reply. Now, my lord, they have to appoint the inquiry officer.
I have to seek instructions. I was not aware about this.
Respondent shall place the objections on record. This is the matter after 2 weeks. Yes,
Notes.
next.
Any date, my lords, are thereafter.
Number 35?
This is the matter on 25th.
Please.
Yes.
Much obliged.
35, yes, Patil, for the petitioner was. Petition Harvey.
Please. Cooperative society election matter, my lord, where this honorable court directed to cast our votes, my lord, election was commenced, my lords.
Yes, Mr.
Now, my lord, pleadings are,
Your objections?
pleadings are.
Yes, I have filed minutes. I have filed, government also filed objection.
What is the case of the petitioners?
It is the case of the petitioners that, my lord, they are the ineligible voters, my lords, on the basis of non-issuance of notice.
The respondent to include the name of the petitioners in the list of the eligible voters.
Please.
Now, why they are declared as eligible, ineligible voters? Yes?
Please, my lords. As per the, my lords, provision, we have, my lords,
Yes. Please let
issue
us see your
notice.
objections.
I have filed statement objections. My lords, that is,
Dated?
my lords, dated 10/10/2000. I have issued, my lords.
29/126, 29/126.
My lord, we have issued a notice on 10/10/25, my lords. That is before 55 days, my lords. That is in annexure R23 to R33. And out of, my lord, 279, 17 are defaulters. My lord, that is in page number, my lords.
How many are the?
Objection filed on 3 February 28.
That is why it is not there on record. It's not there.
Please, my lords.
Now, how many are the petitioners in
Please, my
number?
lords. My lord, totally, my lords, there is 2694 are voters.
Huh?
2694.
Are the petitioners?
No. Total voters in the
How many are the number? How many are in
279,
Huh?
279.
79, my lords. Petitioners are 279.
No,
Out
let us-
of
let us
279.
forget about
Please, others.
So out of this 279, you have declared them as ineligible voters.
Yes, sir.
On what ground?
My lords, ground is, my lords, one is, my lords, one, that is, cost title serial number 64 is concerned, my lords. She is no more.
Then how did they file a writ petition?
That is, my lords. She is no more and her name is record in the account is, that is, my lords, Mahadevi Manjunath Devadiga, 64 serial number.
When she died, 64?
She died on, my lords, that is, I have produced the death certificate. She died on 2/5/25.
Yes, how did you file a writ petition on a dead person's name?
Name are different, my lord. My lord, may kindly peruse page 124 of my writ petition, my lords. Page 124, where her name is displayed, my lords. May kindly be, my lords.
It is a clerical mistake, my lords, that was incorporated in the writ
Be a
petition.
perfect name, my lords.
You need to
They
have
cannot
a-
take a defense of that. my lord.
Where is the signature in the wakalat? Let us see.
Please.
120,
4, my lords.
64, let's see.
Petitioner number 64 name, may kindly be perused at page number 124 of the writ petition, my lords.
Page
Page number 11 of the writ petition, her name, my lords. Mahadevi Masti Devadiga.
No, if you look at the wakalat,
Please.
62,
Wakalat.
63,
64.
65. 4 has not signed the wakalat.
May I permitted to see the original file, my lords.
Give it to him.
Please.
24 only there.
For a moment, my lords.
Two, 253.
My lord, may kindly please to, my lord, page 154 of the wakalat, my lord. Below her name, my lord, she placed her signature.
No, you have given the serial numbers of the petitioners and they have signed. Where is 64?
May kindly be, my lord. 64, next to that particular line, my lord, her signature is appearing. And moreover, my lord, my submission to this honorable court, my lord, the death certificate and the name relied by the respondent, contesting respondent is very much different, my lord. My lord, may kindly peruse, my lord, their statement of objection annexure R1, my lords.
What is it? What is it? Where? Signatures won't be here. Signature will be here. No, that is a description, IB so and so. Signature is in the bottom. Signature is not there. Wakalat signature is not there.
The portion above to that particular line, my lords.
Signature will not be on the top.
Indeed, my lord.
Top is a description.
Lord, my submission to this, my lord, there are, my lord, total, my lords, nearly 280 members, my lords. They
That's
are
why
from
you should
the,
never file one writ petition like this.
lords, they are from the
The difficulties, that's why you should be careful.
two submissions, may kindly be perused, lords.
I produced the account extract of the, my lord, that's.
What is according to you, she has been given there must be a number, membership number.
Please.
Where is the membership number?
Page 124, may I kindly be,
120?
4 of the petition. 124, page number 124.
One 124.
Yes, please, 124. That, my lord, from the bottom 7th person, my lords. Mahadevi Masti Devadiga. Page 124.
Number?
What is the name?
My lord, Mahadevi Masti
Serial
Devadiga.
number 16?
1665.
Share number is 1665.
Mahadevi.
65.
Please, my lord, it is in
What
her
is, her number is?
2253, my lords.
2253.
Please, my lords.
Is it your case that it is the same?
No, my lord.
Please.
No, my lords. I show
64
the
page 11
account statement.
Nimsha.
Madam. She has no account. Madam.
For a
I have
moment,
shown
my
the
lords.
accounts extract.
For a
of
moment, my
Mahadevi
lord.
Masti. Madam.
Where is that?
Annexure R1 minus. R1 minus.
This is
That is R2. That is application minus.
Page 7 of the objections.
Page number 7. All objection, statement objection. In my statement objection.
What is this?
R2. ಮೊದಲಾಗಿದೆ ನೋಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ ಆದ್ಮೇಲೆ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆದ್ಮೇಲೆ.
Have you filed your reply to that?
No.
You should have, when that is such a crucial aspect. What is her name?
Mahadevi Masti Devadiga. Mahadevi.
What is the husband's name?
My lords, Masti, it is written, my lords. But in the death certificate, what my contention before, my lord, they have served copy to, my lords. What I have extracted is that, my lord, this person is different from this particular person, my lords.
What is the husband's name?
My lord, Masti is there, my lords. Masti.
Oh, as per page.
7. Page 7, Manjunath is there, my lords.
Husband's name is?
Manjunath. As per page 7, their contention. As per my records and the contentions, my lord, husband name is, my lord, Masti.
Husband and mother.
This is
Mother.
It is not their contention. It is about the document that is signed by you. You have written your husband's name in this page number 7.
Please.
What is page number 7?
It's the share certificate, my lords. Membership certificate.
So you have signed it.
Please.
The details which are furnished there are the correct details.
But what I am saying is that, my lord, the death certificate and the details are, my lords, different of different person, my lord.
What it says, that's what I'm saying. What the death certificate says.
No, death certificate is the name of the my lords, member is Mr. Mahadevi Manjunath Devadik, my lords.
Husband's name?
Husband is Mr. Manjunath Devadik, my lords.
That is what it is as per this also.
This particular document issued by the bank, my lord, the ineligible voter list, my lord. As per this particular list, my lord, her full name is that, my lord, Mahadevi Masti Devadiga. That's my kind submission, my lords. With respect to
Let them produce that document, my lords.
With respect to that particular thing, my lord, section 70.
The petitioner, it is a contention of the land council for the society.
Yes, ma'am.
That the petitioner number 65.
64.
64 is
my
no
lords.
more, and she died on 2/5/2025. But the petitioners, but the red petition is filed in the name of the dead person. And the petitions, and he has placed before the court the death certificate, which is disputed by the land council for the petitioner. In response, the petitioner shall file his objections or reply or rejoinder to the objections that are filed. This is matter of 2 weeks. 2 weeks.
Date may be election matter.
On
12th or 13th, my lord.
on 26th February.
Please.
It is early.
Huh?
It is early. Some early, my
It's
lords.
on 23rd. 23rd.
23rd, please.
Yes. Done?
One
Any
submission.
signatures?
Serial number 26, I'm sorry, my lords, I was occupied in the other.
What happened to that?
It is listed after 4 weeks. The date may be fixed, my lords, that is my.
After 4 weeks?
Well, after 4, in the next, because election matter, my lords,
List that matter on 19th.
please, Mr. Great.